buildings and online. Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted. Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rules. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that the 3 oral evidence sessions today with the Commissioner Designate for Victims of Crime, the Law Society and the Department of Justice will be recorded by Hansard. So can I seek your agreement for this? Agreed. Okay. Can I remind members that they are obliged to declare any financial or other relevant interest that might reasonably be thought by others to influence their approach to the matters under consideration. So any members have interest to declare in relation to today's meeting, they can do so now. Brian?
I'm a member of the Committee for Justice. Or no, the other one, Committee for Finance.
Finance. Okay. And we're all members of that APG and Access to Justice, so I'll treat that as a blanket declaration, if that's okay with members. Okay. Any other members have any interest to declare? Sorry.
I was part of the research for this Totally Invisible report.
Right, okay. Thank you for that. Aoife, anyone else? No, okay. Agenda item number 1 then is apologies. Do we have any apologies? No.
Chair Morris.
Morris is to come in remotely.
If he doesn't make it, yeah.
If he doesn't make it, well, he should if he can, then if not, then we'll put him down as an apology. Agenda item number 2, draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday the 30th of April 2026 are pages 4 to 13 of the meeting pack? Can I ask members if they're content with the minutes? Or otherwise true reflection of the proceedings of the meeting held on the 30th of April? If so, I will sign. Members agreed?
Agreed.
There you go, thank you. Agenda item number 3 is matters arising. Can I ask members if there are any matters arising for the minutes that they wish to raise at this stage? No. Okay. Agenda item number 4 then is the Totally Invisible report to Commissioner Designate for Victims of Crime and Oral Evidence. Can I refer members to page 15 to 159 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from the Commissioner Designate for Victims of Crime Northern Ireland on the Totally Invisible report, which accounts the experiences of domestic violence and abuse victims, survivors and children engaging with private law family court processes in Northern Ireland. The committee agreed to invite the Commissioner to give oral evidence on this report following receipt of the RAISE paper on the rapid literature review on domestic abuse and family and private family law proceedings. Can I inform members that a copy of the Totally Invisible report, the RAISE paper and the individual responses to the RAISE paper by the Minister of Justice, Finance Minister and the Health Minister are available in the meeting pack for members' information. So can I inform members that the witness providing evidence today is Geraldine Hanna, Commissioner Designate for Victims of Crime, and Louise Kennedy, Chief of Staff of CFO CNI. So you're very welcome to the committee as always, and I'll invite you to make an opening statement.
Thank you.
Thank you.
Thank you, Chair, and thank you, members, for the opportunity to speak to you today. I wanted to begin by commending the committee for your ongoing interest and activism on improving family courts for victims of domestic abuse and their children. As the Chair said, I'm joined by Louise Kennedy, who's our Chief of Staff, and I may hand over to Louise for if any questions get very detailed, because she was the key link with the researchers. So why does this report exist? Well, I took the decision to commission this research really because of what children and victims of domestic violence and abuse have told me about their experience of private law family court proceedings in Northern Ireland and the impact that those processes were having on them. So victims and the agencies that support them were telling me shockingly consistent stories about how they and their children have been subjected to gruelling processes where their experience of abuse was ignored or minimised, where children were being forced into contact with an abusive parent against their wishes, and where perpetrators were using proceedings to continue to exercise control after separation. Now, I want to be clear from the outset, this report, as comprehensive as it is, does not tell us something we didn't already know. Many of you have raised these issues with me directly, based on what you see and hear in your constituencies every week. You know how prevalent these issues are, and you know how complex and damaging they can be for families and the harm that the process can and does cause. What this report does, however, is bring those experiences together into a single, comprehensive, credible evidence base for Northern Ireland. And it asks a simple but difficult question: what are we going to do differently now that we know this? So, some background on the report to begin with. The research was carried out by a team from the Centre for Children's Rights at Queen's University. The researchers spoke directly with 51 individuals. That included adult and child victims whose lives have been shaped not only by domestic abuse, but also by how the family court system responds to that. Both male and female adult victims, as well as male and female children, took part. Young people from the Social Action Youth, or SAY project run by Women's Aid, also helped structure and oversee the research as part of an advisory group. And I want to pay tribute to those wonderful young people who give their time and expertise to help make this research the child-focused piece of work that it is, and ultimately help make things better for the children who come after them. I'm also really pleased to say that a child's version of this report is going to be launched on the 8th of June, and the researchers from the Children's Rights Centre have been working closely with the SAY group in the development of that. The research team also interviewed support organisations, legal professionals, judges and social workers who deliver the role of child court officer to ensure the research captured a broad picture of how private family law proceedings operate and what issues exist for domestic abuse victims and their children. So in terms of setting the scene, domestic abuse is not an edge case in private law proceedings. One of the clearest messages from research recently published to this committee by the RAISE service is that domestic abuse is not a marginal factor in private law child contact cases. Recent analysis by the Domestic Abuse Commissioner in England and Wales showed that domestic abuse was identified in 73% of the hearings and 87% of the case files in the family court cases that they examined. Now, this is far higher than previous estimates, underscoring how routine these issues are in private law proceedings. Now, this matters because the private law system was not designed with this reality in mind. It was designed to resolve disputes between parents who, while at odds with each other, are not in a relationship marred by control, power imbalance and fear. The current process is simply not made for identifying and managing ongoing patterns of harm. So when domestic abuse is present, as it so often is, the system can struggle. And the consequences of that struggle are felt most sharply by children. And that brings me to the main findings from the report. You'll appreciate that it's a sizable and comprehensive document, so I've just chosen to highlight some of the key findings, but if you have any further questions, we're happy to take those. So one of the first findings was that children are present in the process, but are not often heard by it. So children and young people told the researchers that the court process can feel confusing, frightening and disempowering. In many cases, they did not understand what was happening or why decisions were being made, and were left unclear about whether their views had made any difference to decision making around their contact with a parent who is already an abuser. One parent described the impact of this on their child in stark terms, and they said, "My child's voice was not being heard. The child's wishes are dismissed. These are all supposed to be the core things in the family court. It's not how it happens. My daughter's voice has been silenced and silenced and silenced." Children described feeling caught between adults and carrying responsibility they should never have to bear. They experienced fear and anxiety, linked not to the family circumstances, but to the court process itself. Now, interestingly, there was a stark disparity between how professionals thought the system worked for children and how children thought the system worked for them. So, just to be clear, this isn't to disparage the hard work that many dedicated social workers do in this field. Again, it's a case of individual commitment not being enough to hold together a system that is simply not designed to centre around the views and needs of the child where domestic abuse is a factor. But children and young people told us time and time again that they felt they weren't listened to, that engagement with them was minimal, that they felt like an afterthought in a system that is supposed to be about them, centering on their needs. So that is why children's participation cannot be informal or incidental. It must be structured, supported and safe. Seeking children's views, voices and experiences should be the first port of call, out of which everything else flows during contact proceedings. This is also why the voices of group like the SAY project are so important, because children themselves are telling us what participation should look and feel like. Another finding was that court processes are becoming part of the abuse. Survivors described how perpetrators often used repeated applications and hearings, made counter allegations of domestic abuse, and delayed or frustrated proceedings as a mean to continue to exert control and continue to abuse their victims. In this way, the family court process is successfully being used to continue abuse after separation. This litigation abuse, as it's named in the research, had hugely negative impacts on victims and children, especially as it often resulted in proceedings being dragged out and spanning much of a young child's life. I spoke to a female victim this morning who has been going through our family court system, and she's been going through the system for 10 years. One survivor explained the impact in their own words. Being in the family court system is like being with an abusive partner in the sense that you doubt your own reality. You don't know if what you're thinking is even true. It's abusive to me. Rather than providing safety and resolution, the process itself is experienced by many as re-triggering their harm, reinforcing their fear, and keeping them in the very cycle of abuse that they have tried to break free from. This is why post-separation control and litigation abuse must be recognised early and actively addressed within family court processes. And that requires that allegations of domestic abuse are dealt with comprehensively at the outset of any proceedings, and that in cases where domestic abuse is found to exist, that a specific process tailored to address that reality and protect victims and their children is followed. Another finding is that there is a de facto presumption of contact operating in Northern Ireland family courts. The committee will no doubt be aware of moves in England and Wales to remove the presumption of contact in family cases from their law. That decision was the result of campaigning by victims and their advocates, and the subsequent recommendations of the 2020 Harm Panel report, which included an urgent review of presumption of parental involvement in cases where domestic abuse is present. Now, unlike England and Wales, Northern Ireland does not have a presumption of contact written into our legislation. However, our research found that in practice, contact proceedings operate a presumption that the eventual goal of proceedings is resuming unsupervised contact with an abusive parent. And that is dangerous for several reasons. One, it disregards the possibility that contact with an abusive parent may not be in the best interest of the child. Some children told researchers that their experience of abuse or witnessing abuse traumatised them and that they were clear they didn't want to see their parent. Children told us that being forced into contact in these circumstances directly harmed them. It was also clear from what child and adult participants told us is that the circumstances of facilitating contact while abuse was ongoing often had a debilitating impact on the non-abusing parent, which therefore impacted on the child. Secondly, a presumption of working towards contact means perpetrators are able to go into this system with the reassurance and knowledge that pending something absolutely catastrophic, they are going to be guaranteed contact. This gives them leverage in an adversarial process which reinforces the power imbalance between them and their victim, and it gives them a green light to commit further abuse and continued control, knowing that ultimately there won't be any consequences for that behaviour. So what does all this tell us? This isn't about poor practice, it's about system design. So the report does not suggest a lack of commitment or concern amongst the professionals. The findings point instead to structural problems. So adversarial processes which lend themselves to being hijacked by abusers, late identification of risk, a lack of recognition that abuse of one parent by another may directly impact on the well-being of children and cause them harm, fragmented information given to children and victims throughout the process, and limited access to specialist domestic abuse expertise. These are design issues, and design issues cannot be fixed by guidance alone. If we continue to run cases involving abuse through a system designed to mediate parental disagreement, we will continue to see children and victims harmed, regardless of the individual goodwill of the practitioners. So, knowing what we know, how do we move forward? Now, I'm clear that the Totally Invisible report can't be another report that sits on a shelf. It would be a travesty for victims, children and young people who bravely shared their experiences and their views on how to make this system better if we respond by doing nothing. That's why I've set up a task and finish group to look at what a new, safety-focused, trauma-aware, problem-solving model of private family court might look like. Now, the task and finish group is intended as a focused, time-limited piece of work designed to turn the evidence from totally invisible into a practical, testable pilot for cases involving domestic violence and abuse. In terms of who's sitting around the table, we now have commitment to take part from officials in the Department of Justice, the Department of Health, the Department of Finance, the Health Trusts, the Children Court Guardian Agency, the Courts and Tribunal Service, the legal professions and the domestic abuse support sector. I've also spoken to the Lady Chief Justice, who has agreed to be informed of the progress of the group and provide judicial input once we have a draft model to share. Now, as you'll see, the group is deliberately cross-departmental because the problems it seeks to address and the responsibility for addressing those problems cut across our finance, justice and health departments and require the buy-in and support from our children's services and beyond. The group will be chaired by myself, and my aim will be to drive the work forward and facilitate the resolution of any challenges or sticking points that may arise, as well as being an additional voice of victims in the room. Now, I'm aware that a query has been raised by the committee as to why the Department of Communities is not on our list of participants. So we took the decision to limit the group to those with direct responsibility in the area of private family law. And it is a rather sizable group at the minute. But in the course of our work, should we find that we need to reach out and seek input from any other agency, department or organisation, we'll do so. Comparable approaches elsewhere show that where early triage is built in, specialist expertise is available from the outset, and when children's participation is properly supported, that outcomes improve. So, for instance, the Pathfinder model, which is now called the Child Focused Courts, is being rolled out across England and Wales. Now, it started as a limited pilot, implemented in response to the Harm Panel report, and that was that they should need to find a new way of doing private law business where domestic abuse was a factor. So, child-focused courts begin with early identification of domestic abuse and places the child's voice at the centre of proceedings. I had the benefit of attending the Dorset model as part of the pilot alongside the Domestic Abuse Commissioner from England and Wales, and was very struck by the value that was being placed on it by all of the professionals in the room from the outset, particularly from the domestic abuse sector, but also from the judges involved. By starting from the child's experience, cases are less likely to become adversarial disputes between parents and more likely to focus on welfare and safety from the outset. So in the Northern Ireland context, our focus will be on translating the evidence we have into practical options for reform rather than duplicating other models. In simple terms, we'll be asking, what would such a system best look like here, and what might it cost to do it properly? So the work is due to commence in June, and we're currently working on a briefing pack to provide evidence and information base for all the members of the group. I've also drafted some terms of reference which the members will have advance sight of, and so that we can hit the ground running on day one. Now, you'll undoubtedly have more questions about this work, and I'll do my best to answer them, but as we're in early stages, I may not be able to give you a comprehensive certain response. But I would be keen to keep this committee updated on progress once the work of the group is underway. And in fact, I would encourage all members to continue to engage with us on this journey. I really can't overemphasise the importance of political buy-in and setting aside political conflicts to work together to make a real change for victims in this area. The coalition of the willing will be particularly important when it comes to taking action to change the private law system. The Task and Finish group will only scope out what a new system could look like. There is no commitment to deliver on whatever model is formulated by this group. So that is why I want to make a plea to all of you today. Making a difference for domestic abuse victims and getting their children and children in the family courts will require really challenging conversations to be had. It will require cross-departmental and cross-party collaboration. And it will require our Assembly to make this a funding priority when the timing comes. So, members, you already know the severity of the issue from your constituencies. This report gives us the clearest evidence we've had in Northern Ireland for some time of how the current system is being experienced by those who rely on it the most. So the question now is whether the problem exists, but not whether the problem exists, but whether we're prepared to design something better. And I welcome your continued interest in the work. I hope that you will hold my office to account, as well as all the partners involved in the Task and Finish group as this progresses. Children and victims have told us what is wrong. We now have the opportunity to show that we are willing to act. Thank you.
Thank you very much, Geraldine, for that. We're going to go straight into questions, so I'm going to ask Brian.
Okay, good. Thank you for your attendance today and for the copy of the report. And every case around this is a difficult case, and the circumstance of each case obviously needs looking at, but you're trying to draw some overall conclusions. Just to say, I declared earlier I'm a member of the Finance Committee. When I joined Finance and Justice Committees last September, I didn't realise there'd be so much overlap on civil law and family law, and I see things like Jade's Law, that's primarily the consideration that's going through finance. So it's useful for me to see that these matters progressing. So a few questions. I think you said it was 51 individuals you interviewed, male and female victims, male and female children. Were any of those parents from the same relationship, which was a separation? Were any parents from both sides, if you like, of a separation?
My understanding would have been no.
Right.
So any of the ones that were involved would have been identified. So the researchers were very clear in terms of how they engage with victims and survivors, that there needs to be support services available. So those individuals would have been identified by either Women's Aid or Men's Advisory Project.
Right. So none of those were people. Were they all the person who was retaining primary parental responsibility for the child? Then?
Not necessarily. Now, I don't have the specific details of all of the individuals, but
it's our understanding. So in the actual research report, I don't think that was broken down necessarily, but I do know that, obviously there's a spread of female and male victims, but those circumstances are not necessarily the stereotypical circumstances, but the focus of the report was not on those specificities, if you understand what I mean.
Mm-hmm.
So I don't believe that there would have been two parents both saying that they were victims of domestic abuse with one child, if that's what your question is.
Well, I mean, all of us have spoken to people, and we as elected reps get approached from people who are aggrieved, with these circumstances, and I always have to say to them, there's not much I can do by way of intervening. I can pass on concerns, but I can't get involved, in something which is a legal matter. But I do often hear from parents who are not having access to their children, and also grandparents. And my overall position, and I've recently joined the committee, I realise it's a longer process. On the whole, if contact can be maintained with both sides of the family, I think that is good for the child on the whole, if that can be achieved by agreement, rather than having children cut off from one side of their family unnecessarily. And that would be my general view. I think it is healthy that children, where there's been a separation, if they can at least maintain contact. So I am cautious about a rush when you're saying a presumption against contact, and I know you're saying that in cases where there's been domestic violence or abuse established, but I'm wondering what the threshold is for establishing domestic violence and abuse, because most separations will have involved probably hurtful words being said, abusive words being said, angry words being said. Does that count then as abuse if somebody says, well, something very angry or hurtful was said to me? And I mean, every situation is difficult, but it's quite likely things have been said that both people will feel they've been hurt. So yeah, that's my concern. Where's the threshold for something that would be an allegation of abuse and could result in contact with the child being lost?
I think the points you raised are really important, because I think as we break that down, we can really distill this into what we're focused on here. So where we have two parents who have a disagreement, they're separating and there's maybe disagreement around contact, where there's no domestic abuse, there may have been harsh words said, hurt feelings, that doesn't equate at all to the threshold around domestic abuse or coercive control in particular. That's nearly what our system was set up to deal with. But where we're talking about is where there is domestic abuse present. And one of the things that we're hearing from in both this research and other victims' families speaking to me is that determination, and you're really the crux of your question around the threshold, that's not being heard early on. So domestic abuse, the consideration of whether or not domestic abuse is present is not automatically being looked at the beginning. So the model that the Pathfinder model looks at, what we hope to learn from is where there is an allegation of abuse, that is determined at the outset. Because in determining that, then that sets the pathway as to what will be followed next. And who determines that threshold? The judge.
Right.
So that will take into the individual circumstances of everyone involved. And the other key part of this model, alongside determining any allegations of domestic abuse at the outset, is the voice of the child. So getting their views and thoughts and experiences captured early on. What we're seeing through the research and other feedback is that individuals where there is domestic abuse alleged, it's not happening until later. Our children's voices sometimes aren't even being captured at all in that. So this new proposed way forward will be child-centred, trauma-informed. Those cases that don't meet the threshold for domestic abuse, where there's a judgment made that domestic abuse hasn't been isn't involved, then it goes down another pathway. But what's so important is ensuring that we have that determination from the outset, because that will really help inform the judge, particularly where we see repeated applications and we're straying into potential litigation abuse.
So it's the judge would make that judgment based on evidence.
Yes.
I mean, because I've heard
Including
from
the child's voice.
Yeah, I've heard from people who feel that there's unsubstantiated claims made and that they are punished then by not having access to the child or having very limited access to the child. But are you saying, in terms of so the having access to the child, if that's the right word to use, sorry?
Contact with
the child, yes. That wouldn't be, is that made by social workers in any cases or in extreme cases?
So the child court officer will make a recommendation following meeting with the child and looking at a range of circumstances, meeting with the parents, potentially maybe engaging with schools and other influential people in the child's life. But ultimately the decision around contact is determined by the judge. But what I hear from people is that allegations around domestic abuse aren't being explored, are being dismissed, are being set aside. And the whole idea of around your very opening remark about contact with both parents is beneficial. I think that everyone will agree with that as long as that contact is safe.
Yeah.
And what we're trying to determine, and where there's domestic abuse present, there needs to be a question, is that safe? And that's for the judge to determine. So we're not saying either that where domestic abuse is present, children should never see the abusive parent, but that there's a shift rather than us working towards trying to build up to contact with the parent, that we work on the presumption that where domestic abuse is identified, that it's not safe until the perpetrator, because they've now been judged as a perpetrator of domestic abuse, can demonstrate how they can maintain safe contact with their child or children, and that there's not an ongoing pattern of abuse with the non-abusive parent.
The other question I want to ask is what you're saying, child-centred process, and that sounds positive, but I'm wondering if that comes into conflict. Does parental rights exist anywhere in this framework, and the potential for a child for the other parent to if you had a circumstance where the child was being almost encouraged to say, I don't want contact with one of my parents, is that enough to prevent that contact? where there hasn't been proven abuse?
So if there hasn't been proven abuse, so we're then taking domestic abuse out of the equation. Obviously the child's wishes and views should be considered, but the child's wishes and views are that. They're the child's wishes and views. What we're really, when we talk about it being child-centred, it's that we are engaging with children from the outset, that they have a voice and a space to share that voice, that they are kept informed, but it's never their responsibility in terms of decision making, because that would put an awful lot of responsibility on a child.
And pressure could be brought to bear.
Pressure could be brought to bear. That the judge's role and social services, when their involvement as well in terms of the recommendation, will be considering what is in the best interests of the child. Their voice should influence that, but it's not that a child has a veto. If that's helpful.
Yeah. Oh, no, I'm just thinking of circumstances. I mean, this is the sort of thing that's been said to me in some cases. People feeling that. With allegations made and if they say that it hasn't happened, what is alleged, and that the child is being persuaded, they feel, to speak against contact.
Yeah, and the model doesn't remove, or certainly any of the models in England and Wales or Australia that we're looking to doesn't remove parental responsibility either for the children involved. It's really about it's having the child's voice more central in the process. So what we heard particularly from the children and young people is that, well, the legal professionals had indicated that in children's court officers don't often see the child in like half of cases, which, you know, it was quite shocking for me that it would be as high as that. But what is clear is that we want children to be consulted, that have a level. Really what's promoted through this is the Lundy model, where the child is given space and that they're seen in an environment that's comfortable for them, that they have a voice, that there's an audience for that voice, which is really the court and the judges. And of course age and maturity play into that, and also that there's an influence, and that when a decision is taken, and probably more importantly, when a decision is taken that goes against the wishes of the child, that it's explained to them and it's not left to a parent or another teacher or whatever to explain it, that it's actually explained to them through a formal process via the court. That could be by the judge writing to the child, it could be by the judge meeting the child. But again, that sense of, we don't want children to feel that it all rests on their shoulder. We want them to be appropriately consulted and involved, because ultimately it's their well-being in life. But where it doesn't go with their wishes, but also where it does, that's explained to them. And I think what's particularly important, and where it's very young children, so say if we're talking about maybe a child of 1 or 2 and there isn't the same opportunity to explain to them the rationale for your decision, where judges can write a letter to the child to explain why they made that decision, so that child can have that when they're older. These are all the kind of best practice examples which we want to explore as improving the model, and is really what is meant by a child-centred, trauma-informed model of contact.
Very briefly, appreciate it, given time. So in terms of what are you seeking at the end of this? Would it be legislative change, or would it just be guidance?
So really what I'm seeking at the end of it is a whole revised model for child or for our family private law systems.
Would that require legislation?
It may require legislation, but it would not require legislation to pilot. And interestingly, this whole Pathfinder or child-focused courts model that exists in England and Wales came on the back of a practice direction by the head of the family courts. So it happened without legislation. I would like to think that once, if we get as far as getting the pilot funded, if we then got as far as being able to roll it out, then you would look to update the legislation, but that legislation would be much better informed. And I think when we think about the legislation that's underpinning a lot of this, it's really quite dated. You know, you're talking 95, 96, 2001, at a time when domestic abuse, in terms of awareness and understanding of domestic abuse, wasn't anywhere near on the radar as much as it is now. But even when you think of how far we've come in the last 5 years around our understanding of coercive control, and a lot of this, the coercive control is what we're talking about in a lot of this. So the parents have separated, so the victim has managed to separate from their partner, but there's a ongoing coercive control element, and the court system in its current format is being used to help facilitate that. So I think a review of legislation is required, but it's not the first point, the first starting point, because I think there's an opportunity for us through a pilot to test how this would work, and then you would belt and brace this with legislation.
Okay, good.
Just on that, so we all know domestic abuse. Some of us who are steeped in this know what coercive control is as part of domestic abuse, but that's not always obvious, or some people don't always understand that. We can all see the black eye, we can all see the broken arm. I suppose is the simplest way to put it. So when you talk about domestic abuse within your report, do you really mean coercive control? And are you confident that the judiciary and the system sees it like that also?
So in terms of the victims involved, some of them would have been domestic abuse in its fullest form, including physical violence, financial abuse, emotional abuse, psychological abuse. Coercive control is a key component in all of the cases, though, and it's the coercive controlling element that is continuing to be perpetrated as through the family court system. With regards to your question around, am I confident that all the practitioners, judiciary right the way through, are as well versed in this as what they need to be? My answer is no. And I think all of us, and it's no, I don't mean to disparage any of the professionals involved, but there's a significant learning curve in society around what coercive control is, how it manifests, and how our systems can be used really to help facilitate it. So there's a significant piece of work around training that would be needed with social workers involved, so the children's court officers, also around our judges, so that we are able to effectively spot that, our legal professionals involved, and also society. So it's that broader piece, but it's vitally important that anyone who's making decisions around child contact and is involved in that decision-making process are well versed in the most up-to-date best practice and learning in this regard.
Thank you. Connie?
Yeah, thank you, and thanks for coming today. I think this evidence is so important, and I think it gives us a really good evidence base to push for change. Something I wanted to pick up on that you'd said was the Task and Finish group obviously has a big workload in front of it, but I think it's so welcome. Was I right, and I heard the judiciary said they'd like to be kept informed of the progress of the group? Are there any judges or representatives of the judiciary on the Task and Finish group?
No, there isn't. When I met with the Lady Chief Justice, the main reason for not engaging at this point was around capacity. So there wasn't capacity to sort of free up a judge to attend it. I think it would also be fair to say that the Lady Chief Justice is also keen to ensure that if we are doing any pilot in this area and reform in this area, that it needs to be appropriately resourced. So I think the judiciary are mindful that there is potentially significant change involved in this, and that the resources need to be in place. I'm really pleased that the Lady Chief Justice has offered to look at what we've suggested. I know that they have obviously the Lady Chief Justice issued guidance in this area, which is all very welcome. We have a pilot that they're running around family resolution, which excludes domestic abuse cases, but I'm hoping to connect in with that to see if there's any learning that will help inform our proposed model. And when I say our proposed model, let me be very clear. I'm not an expert in family court law, and I'm very open about that. We're facilitating the group because of the range of agencies involved and departments involved. The experts in that room are the people who are sitting around it, which is why I'm so pleased to have such a great range of commitment from departments and other agencies to be involved. In terms of the judiciary themselves, we will feed feedback into them, and again, any progress in terms of the pilot will require judicial buy-in and support. But hopefully we will have, we'll get the funding committed to, and then we'll be able to secure that.
No, thank you. I think that is disappointing that there's no representative there. I personally think this is just extremely important work, and I know it's something this committee is focused on, and individual MLAs as well. And I was wondering as well, as part of your research, I know the LCJ issued guidance back in 2025 on domestic abuse in family proceedings. Have you done any work or looked into that guidance, and do you think that's made much of a difference?
We haven't done any significant sort of analysis of it, so I can't speak to is it making a difference on a daily basis. First and foremost, I'd say the guidance is welcome. It's really important from the head of our judiciary to have that commitment, understanding and recognition, and there's some really great principles outlined in that guidance, so that's really, really important. But I suppose what I would say is, what we're talking about here is a fundamental reform of the processes. So guidance isn't enough. When I talk about how long ago we developed this model, we're literally, talking 20, 30 years ago, and without the whole benefit of our understanding around domestic abuse and coercive control, it's clear that we need a model that works in today's environment, and that's a system change. So judicial guidance is very welcome and helpful, but what we need is meaningful change here, and I think that will require a whole process and structural piece, which will then no doubt be accompanied by the judicial guidance that will go alongside and support that.
Just last point, please, Chair. I think on your recommendations, for me, the presumption against contact, I think, is extremely welcome. I know the culture of presumption against contact is so strong that whenever they were looking to remove it in England and Wales, I had people contacting me asking how we can do that in Northern Ireland without even realising that wasn't the case here. And do you think the reason why we need a presumption against contact is because that culture of no contact with abusive parents isn't working in the best interests or the safety of children?
Yeah, I think everyone accepts that, regardless of whether parents are together or not, children will benefit from contact with both parents in their lives, even if both parents aren't necessarily in agreement with each other. But where we have domestic abuse, it's that recognition of the impact of domestic abuse on children, and I think that's even evolving. So, in our own Domestic Abuse and Civil Proceedings Act, where we recognise children as an aggravating factor, we're learning more and more, and we're learning more and more because those children are growing up and are now lobbying and changing it, as to what the impact of domestic abuse has on them. So, whilst we have never had the statutory presumption of contact, we nearly have inherited it and embedded it in our practice. So we're not saying, again, I suppose I'll re-emphasise this, where domestic abuse is present, what we're proposing is that there is a presumption against contact until it is proven safe for it to be so, rather than presuming that it is safe and then finding out afterwards that it's not, and really placing the onus of responsibility on the abuser to demonstrate to the court why they are safe, why they can be safe, safely in contact with their child or children, and also that there is clear recognition that any coercive control of the non-abusive parent is not continuing.
No, I think you've made that. I think that you've made that very clear. This is absolutely not about presumption against contact with both parents. It's about the safety of with children contacting an abuser. So, no, thank you for your work on this. It's really, really welcome.
Okay, Patsy.
Yep. Thanks very much, and thank you for all your work that you've done. Can I maybe just talk you through, we'll call it the process, maybe a better idea would be the experiences of some people. Sure, all of us in this room have been in situations where we've encountered, most cases female, big shining black eye, and they've walked into a door, right? And we all know that that's not the case. So how do you see a growth in awareness, a growth in confidence for people to come forward? How do you see it, and possibly what role is there with, say, the likes of the Department of Health, with psychologists, psychiatrists and the like of that? Now, the second bit then is, whenever, if that person has opened up and has identified a pattern of harm, and this is something that has I've laboured over thought-wise myself, and they get the length of court, either they or their children, because you mentioned children given evidence. What methodology or what issues have you raised with, say, the court service to ensure that there's a thin line between the discernment of facts and the establishment of facts, and basically the re-traumatisation of the individual or their children having to give that evidence, if you get where I'm coming from as well. And that relies a lot on I suppose they understand the sensitivity of the judge and the direction of the judge to rein things in as well. So that's another aspect that I've thought quite a bit about. People being re-traumatised by, if you like, the reenactment of what they have come through. Then and Connie has touched on this, the issue of contact with an abusive parent. Would it be your case that where it has been established there is a sole abusive parent in a relationship, that you prevent contact then if there are children with that parent? Is that the direction you're going, in order to ensure that the children themselves either A, don't become a victim, or B, pick up the worst habits of that parent, and they then too become an abuser? Because that often there can be a pattern where that does happen if the worst of real bad habits are encountered or learnt by the child. So I would be interested to hear just what your thoughts are on that, please.
Okay, so that was a lot.
I know, but
So I'll try and talk through it.
That's the reality.
If I get it, if I miss something, tell me, and Louise will keep us right here too. So in terms of the broader piece, how do we encourage people to come forward? It's beyond obviously just family courts. So I think the more we do around raising awareness, public understanding of the issues, we see campaigns happening. We have things like violence against women and girls. We've got our domestic violence, sexual violence strategy. All of that work is important, and the more we can do to increase that understanding is essential. And with the week that's in it, the review of the Katie Simpson case is as tragic that, and the litany of failures there is incomprehensible. But what it has done is really shine a light on our understanding of domestic abuse and coercive control. So there's that broader awareness piece. If I bring it down to the family court, ensuring that all of the practitioners are properly trained is key, and that includes the legal profession. So solicitors need to understand the dynamics of coercive control, because they inevitably are going to be the first point that both parties end up engaging with. So their understanding and training around that by specialist organisations will help inform their understanding and how they approach that. What I think is important, and it's sad in this report as well, that some people were concerned about raising issues around domestic abuse. They didn't want to highlight it. So that can be for numerous of reasons. Some of it is around fear of then counter allegations and advice from solicitors not to raise it, which is a concern. But also shame and not wanting that to be out in while they're private proceedings. They're still sharing it with someone else. So there's a lot of work that we need to do as society to break that down. But I think, we start with our legal profession, the judges as well then as part of that. As part of the process and the child-centred piece, that trauma-informed piece is essential, because some of particularly the children involved in this research were kind of disturbed by some of the engagement that they maybe had with children's court officers, because it was maybe one-off. There was no sense to build up a rapport. And that can be a difficulty, which then can cause further harm and re-trauma. With regards to adults, victims engaging with the process, one of the key things we need to be considering is around the space, the accommodation. What came up in the report, and has also come up with me in other conversations with judges actually, is around having to bring people together into one room. And I would be a strong advocate of us being able to facilitate site link a lot more, so that where we have two parties coming together and there's allegations of domestic abuse, even if they haven't been investigated yet, where there's those allegations, that we facilitate people being able to give evidence from other locations. Now, we brought in, as part of the Domestic Abuse and Civil Proceedings Act, the special measures are there to enable that, but I don't think that should be something that is seen very much as a special measure, as opposed to, if there's any allegations, particularly after when there's if there's a finding of this, that we wouldn't have, we would offer the victim to be able to give evidence from another location, so we're not bringing people together, because again, where there's domestic abuse has been found and coercive control exists, if someone is determined, if an abuser is determined to continue to abuse their partner, they are going to be wanting to get in the same room with that person. So we need to offer opportunities for that. And then, and I'm not sure if this is your last point, but I'll make this point too, in terms of advocate and contact with the abuser. So I want to be really clear, I am not saying that my view is that anyone who has been found guilty or found to have, even in the family court, if there's a determination that there was domestic abuse, I'm not saying that they should never have contact with their child. What I'm saying is that we start with the presumption that contact is going to be unsafe because of some of the reasons you've highlighted around potential patterns and the impact also that domestic abuse has on children, but that we then put the onus on that individual to demonstrate to the court how they can safely be in contact and parent the child. That isn't impossible. We have things like perpetrator programs. I do not believe that people will never be reformed. If someone has been a domestic abuser, they may go on to domestically abuse again if there's no intervention, but if we have successful intervention, then that doesn't necessarily preclude contact with the child, but the onus should be on them to demonstrate how they can ensure that. And there should certainly be evidence to make sure that we certainly should be checking to make sure that they're not continually to abuse their partner or ex-partner at this stage.
Thank you for that. Just one other thing, Chair, and it's back to the courts, as you will well know, where there has been a separation, particularly acrimonious, there'll be one partner or the other, or both, will be up for something quite adversarial. So how, in an instance where, again, back to the issue of someone simply stating facts to have been re-traumatised, how do you arrive at the point, or what course do you see it taken with the judiciary, or indeed the legal representatives who may be up for a fight, for want of a better word, on the instruction of their client on either side? How do you ensure that the process itself then moves from being adversarial stroke re-traumatic over to conciliatory resolution?
It's a really helpful question, Patsy, and it's actually one of the things that struck me the most whenever I went to visit the Dorset model in 2023, and it was Judge Simmons actually who was the lead judge, and he began the session, and what was really powerful from my perspective was he outlined how he was so averse to even beginning this pilot. So he had just inherited that patch, and it was the judge before him who had agreed and signed up, and he was like, so cynical, this wasn't going to work. And he was a total convert. And what he said, the biggest difference was how they turned it around from being so adversarial was you start with the child. So rather than starting with he said, she said, or she, regardless of you don't look at the parents first, you go to the child. So where there's an allegation of abuse, first of all you identify. So the process in the Pathfinder is the papers come in, there is an identification done by a paralegal, questions are asked, is there any domestic abuse involved? If there is allegations there that it is, a children's court officer, in England and Wales it's CAFCAS, would meet with the child and they capture the child's views. What he was struck by was how many cases were resolved at that point, because when both parents heard the views of the child, it took it away from Mummy said, Daddy said, into Johnny's saying. And for some, not all, it was able to be handled on papers and an agreement was reached, so it reduced it having to come before the court. What that left them with was the more complex cases. They then moved from that to the fact finding around the domestic abuse. Again, it's getting that adversarial piece kind of dealt with up front, and then you take it from there. So all of the outcomes around Pathfinder and evaluations to date is it reduces the number of hearings, it is less adversarial. One of the challenges we will have, obviously, is we need to bring our legal profession along on this journey, and that's why it's so important that we have them on the Task and Finish group, because we need them to understand the driving. We need the driving factor behind this, the understanding and awareness around coercive control, but also ensuring that we develop systems that work for the child, and there will be associated things around hearings and legal aid and all of that, and we need to make sure that all works smoothly and that there's no incentives to come into a room. We want to de-incentivise having to come into a room for all parties involved in the whole piece. Does that answer your question?
Thank you for that.
Okay,
Thanks.
Aoife?
Rachel, thank you.
Thank you. And look, a lot of I suppose the questions have been answered. You have alluded to them in your responses. But look, I'm just going to start off by saying that thanks for your presentation today. But furthermore, that I want to thank you for taking the time to actually do this piece of research, because we have seen over the last number of years, unfortunately, the massive gaps, A, to the access to justice, and B, that the culture in the courts is very, very poor. And that's not to say that there is very, very good work that's going on in it. There's very good people, but it's not a tied-up system. They are still working in silos, and I think we see that. The more we read, the more we realise that that's the case. One very evident thing is where the family courts do not tie over with criminal courts, and that's a huge frustration. And I just want to make an additional point, because I think it's very, very important that, particularly in my case where women are coming to me and they are saying, look, I'm going to tell you my story because I believe that changes can happen. Now, I know these changes are not going to help me, but they're going to help other women and children, and I think that shows amazing strength in women and the stories that they do tell of their real life. And just in and around the coercive control part, we've heard people saying today about, how do we identify what coercive control is? There's no physical evidence, there's no black eye, there's no wound. But for a person who is a victim or survivor of coercive control, that wound is as deep as it would be if it was a physical wound. And I think that's made even deeper by those who don't understand it, because that's where the re-traumatisation comes from. So just based on that, on coercive control and professional understanding, there is a clear theme throughout the report that coercive control and post-separation abuse are not always fully understood. And I would say not understood at all in some cases, or recognised within the system. So from your perspective, how significant is that gap in understanding among judges, legal professionals and court officers, and what specific changes are needed in training, guidance or practice to ensure that these dynamics are properly reflected in decision making?
Thanks, Aoife. I suppose in terms of why we're doing, and the thanks for looking at this, this is driven, and our interest and my focus on this as part of my term has been driven by the people who have engaged with us, and every single one of them, and particularly the children and young people involved. Yep. Everybody has been involved because they have wanted to improve the system for those who come after them, and it's credit to them, and this report is for them. And that's why I'm so determined that we have to do something, because it can't just be this report. So we're there, and we'll keep championing and shouting about it. In terms of how good is the understanding, I think it really varies, and it's echoed throughout the report. There's inconsistency at every level. There's inconsistency in approach to some of the processes, but there's definitely I think a journey around coercive control understanding across society, but amongst some of these practitioners, social workers, judges, legal profession. That's why it's so important that as part of the group, we look at what that, and the report recommends mandatory training, which I support, and that's mandatory training for everybody, judges, social workers, legal profession, anyone working in this area should have a certain level of coercive control understanding and domestic abuse, because as you say, in many ways it's the coercive control is more damaging. And so many victims, far too many, have said to me that they would have preferred that the physical abuse, it's that ongoing, and that's where, having managed to escape an abusive relationship, for it still to be continued and perpetrated and being facilitated and further harm being caused in engaging with a system that's supposed to help protect you and your children. It's paramount that we get this right. So part of the work of the Task and Finish group will be identifying what does that training look like, how often should it be, and how do we ensure that, how do we make it mandatory? How do we get to the point that anybody working in this, is that tickets for solicitors that they have to have reached a certain level, judges who are working in family courts needing to have done a certain level of training. But that's where the real work of the group is going to come in, and there is a lot of work to be done.
Yeah, I agree. And I think I certainly have had women who have come to me to say, do you know what, I understand that this is coercive control, I understand that that's now what I was going through, but didn't at the time of sitting in court with her abuser feet away from her. And I think, there is an educational part needed with the people who are involved in the case, particularly with solicitors, because, it's very timely that you are having your brief today, because we've had, obviously, Katie Simpson's family in, very bravely coming into the chamber this week, and then we've had our motion on protecting victims of coercive control. And I think women have, as I said, have come to me and they have said, I now understand that, but the people around me didn't understand it either, and therefore it wasn't recognised as domestic abuse. Therefore, we're never, obviously we know there's good legislation in place in terms of the waiver for the legal aid, and that's not being, there's a couple of different reasons why that's not being offered to them. A, the complexity of it, and B, because they don't understand that this woman is actually suffering abuse, and that litigation abuse is a very, very real thing. So I think there's, and I'm sure you agree, and you've already mentioned in your comments, that education is absolutely needed across the board, and it needs to be tied together. Okay, look, thanks again. I could go on forever, so I am going to stop it there, because I know there's other people need to ask questions, but thank you very much.
Well, you can keep bringing us back.
No, I know,
more questions as we progress.
Yeah. Thank you, Emma.
Yeah.
Thank you, and thanks to you both for coming in and for the report. And it's tough reading, and this whole area is tough, I think. And like Aoife and yourself had referred there to, what we learnt this week in terms of the investigation into Katie Simpson's murder and all of that. And what struck me, in both in the report itself and in the sort of chat that we've had around it, was how convincing that person was, and how charming he appeared to others. So it's kind of there's a couple of parts to it. It relates back to what Patsy was asking as well. I'm really glad to see a focus on this, because I feel like across our public services here, we're piecemeal and we're reactionary, and an awful lot of the time, like it is the truth that, like, hurt people. You'll find that abusers have came from households where abuse happened, where people who are suffering from addiction and mental health issues, it's as a result of behaviours that they watched or were victim to in their childhood, and all of that trauma, when it's not dealt with, will always re-emerge later in life, and it causes an awful lot of the problems then that we have around justice response, and the fact that people are criminalised when really what they need is support. And I know that it's a massive conversation and it's a massive piece of work, and for that reason I really salute you and what you are trying to do here, and I hope that it is taken seriously. But you see what you're talking about there in terms of mandatory training for all of those people who are engaged in the judicial and family court specifically. I was delighted to hear you say that you've got buy-in from the health trusts. how do we normalise that across the board? Because, and others have mentioned it here, as elected reps, I'm contacted by people and there can be claims and counterclaims. And a lot of the time your gut is telling you, but you're not sure. And, you know, I'm not trained, I'm not a professional, I'm not equipped with the skills to identify who's telling the truth here and who's not. But I'm coming into contact with these people in my role. I would have hoped that the professionals within the judicial or within the health services would be, and that doesn't seem to be the case.
Yeah.
Sorry.
No, you're okay. Let me put on record, this is not easy. And, you know, I think it's clear in the questions and, you know, in the report as well, this is a really complex area, particularly when we talk about coercive control, because it's not as visible as a physical assault. So there's, and of course people have a right to defend themselves in terms of allegations against them, and that's all really important. But that's where it is so important that we get the right training in place with regards to how do you ensure that everybody has it and how do we make it mandatory, which I'm thinking you're asking me. That's going to be the challenge that we'll need to think about as the group. How do we ensure this is rolled out and embedded? And obviously there's an issue around getting the pilot up and running if we're able to get the resources for that. And if we're getting the resources for a pilot, the pilot's about learning, but there's an expectation from my perspective that if there's a commitment for a pilot, that there will be commitment to reform the system following learning from the pilot, which will then require your funding first and foremost, but your legislation piece, and that's where you can start to think, I was picking up on Brian's point about legislation, if we are looking at changing the legislation to support a reformed model of family courts, we can start to build in things around the level of mandatory training that should be available for everyone. Once you put that in statute, you're more likely to get there. In the shorter term, we're going to be working with the goodwill of the agencies involved. It's engaging with the likes of the universities who are delivering social work training, engaging obviously the Judicial Studies Board and what they're doing with the Law Society and the Bar, which is why I'm hopeful that we've got the right people sitting on the group. I'm ambitious in terms of how long I think it'll take. I'd like it to take us. It'll probably take a bit more. In my first meeting, they'll probably laugh at me. But I do want it to keep it as time focused as possible. The other thing is, well, which I think it's important for me to have on the record, is this is not going to be the panacea to domestic abuse. This is literally just trying to improve one aspect, our family court's handling of this. There's so much more that we need to do in this area. Ensuring that our family court practitioners, regardless of what their profession is, has a mandatory level of training is one aspect, but there's so much that we need to do in the criminal sphere as well. In our health trusts, you know, we heard it, you know, in Katie's case this week, the missed opportunities. So there's a lot of work to be done, but one of the challenges I've found in this area is that there hasn't been one lead organisation or one lead department, and I find that frustrating at times because I feel like I'm kind of being batted off against other departments, which is why I'm so happy that all the relevant departments have agreed to be part of this. So whilst that, I think, has meant that over the decades it possibly hasn't had the attention that it would have had. So you'll see in the criminal side, in terms of domestic abuse and development, we've done so much more. More work to be done, let me say, but we've done so much more, whereas in this side we haven't, and I think again that's because there hasn't been one lead. But whilst I will criticise and point out the negative side of that, the positive is it means that we've hopefully got the cross-party buy-in, the cross-departmental buy-in, and the recognition that this is an issue that cuts across all. And you know, it's back into your other point around the impact of domestic abuse on behaviours of others and how the children can potentially learn harmful behaviours. You know, if we get this all right, it cuts across into Department of Education, communities, the whole piece. But short answer, if we get the pilot, then we get the rollout, then we get the legislation, and once it's mandated, it's harder to run away from. But I do think that there's a willingness there. It's just the resourcing and capacity piece that we need to work on.
Yeah, just one more. So, and I don't want to like make you uncomfortable here, but I know that in the past week we've heard that the PSNI, there was inherently misogynistic attitudes within the PSNI, and I know that there's reference in the report to the fact that we live in a society that is culturally patriarchal, and Ireland as a whole has had that, and we have that fear from people who may suspect that something's going on, whether it's physical violence or domestic abuse in some of its other forms. But you know, we have that culture, you don't talk about what goes on behind somebody else's doors, you don't call it out, and then we have a situation where a woman is killed and then the whole country knew what was going on and everybody, oh sure, aye, and it's common knowledge then after the fact. And I find it frustrating because, I mean, you can't make judgments or make accusations or get involved in other people's personal business, but oftentimes that does allow abusers to act with impunity, and is what allows them to get away. Would you say, or would it be your view, that same misogynistic attitude exists within our public services and within our court systems, in that even that when you talk about the pro-contact attitude always being advised or strove for, even at times where it has been damaging to children, do you think that is that what the root cause of the problem that we're working with here?
I think that it's inevitable that misogyny exists across all our professions and public. If you know, I don't think it's unusual that we've identified this week that there's misogynistic attitudes in the PSNI. They need to be working really hard to vet people to make sure they're not there, because if they don't get it right, they're heaven help the rest of us. But I think it's inevitable that it's going to be there. When it comes to the kind of pro-contact culture, I think that's been driven really from a sense of people wanting contact with both parents and seeing the benefit of a child having a relationship with both parents. So I'm not sure I would necessarily equate that with misogyny, but I would also say there's such levels of unconscious bias in all of us that we're not always alive to it. So it's not that people are acting maliciously against someone, but there is a bias there, and when we talk a lot about victims' experience, there's been a lot of minimising of victims' experience in the past, and also victim blaming, and that again can feed into our judgments. So it's so important that we don't just anybody who's, particularly if you're involved in decision making around someone's life, that they have the right training, but that there's refresher training and that we keep up to date with that, because we're all still learning.
Yeah.
But work to be done.
Yeah.
Okay.
Thanks.
Hey, Ciara.
Thank you, Geraldine, and obviously this was long overdue, this report, for someone who've worked in the field of family support for many years, and to be honest, I just want to recognise our family support hubs that are in our neighbourhoods and communities, because they've been doing a lot of the heavy lifting, particularly the Ethos Hub that we run, because they were mentoring both men and women. They had to mentor them through the system, because there was no one else was actually assisting them. So this is, I'm quite emotional because it is really long overdue for so many people, first and foremost. The system has been failing, and I think we do need a root and branch review of the whole system. I do welcome the Lady Chief Justice guidance. I think that will go a long way in relation to the court system. In her guidance, she says there would be a review in 6 months, and we're 5 months later, and I haven't seen a review, so that's probably something we can follow up on to get a review to see how that's going. It needs a root and branch review, and I welcome the pilot. I'm cautiously optimistic in the ongoing work that you need to do, particularly given that the judiciary is not in it, and I don't know if there are any other partners that should be in it that aren't in it, because if they're not in from start, they don't feel the ownership of the model, and I think it's quite difficult then to be able to implement. You need all the willing partners around the table from the start to actually buy in to the changes and the significant changes that need to happen. And then two other things, I think, given that we've got here, and it has been through the expressed opinion of particularly those 51 individuals, men, women and children who have fed to this, how can we ensure that those voices continue to be embedded in to the overall change? That's probably one question. And then secondly, I suppose that one, and then the other one would be that I would like to know, we can't wait on a model either. Okay, so we've got the Lady Chief Justice with some guidance from the courts, which is good. Has there been any changes to probably the health side of stuff in particular? Because I'm not disparaging any social workers and stuff. I know they have a tough workload to work with, they're under pressure, but all those other professionals prior to it even getting to court are most critically important, which feed through to the Children's Court order, who are then making a representation to the court. So all those that have been engaged with the family, with the individuals, particularly those that are tied up in the criminal courts as well, because there has been that long disconnect that needs to happen. It's a cultural change that needs to happen, and we don't need to wait for a new model either. So I'm just thinking, from your report, I suppose it's just a general feeling of what's your thoughts on a culture change, and you have health and you have justice starting to make those changes, regardless of waiting for a model, we're waiting for legal changes, you know, because it's just, how embedded is this report? How much have they read it?
This is hard. If only I knew. Well, first and foremost, your very first point, let me be clear, we can't do this without the judiciary. I would love a judge to be on the group, but I'll work with what we've got and we'll continue to engage with them. And I know that obviously the Lady Chief Justice has a very keen focus in this area, so I'm hopeful that if we get a commitment to fund a pilot, that we will get the judicial support and buy-in. So I'm really hopeful about that. And again, in terms of people on the group, I'm hoping that we've covered kind of every base we can think of in relation to that. I have taken an active decision not to have victims and survivors as part of this group, which builds on your other question, which has, because it's very operationally focused, so it's the practitioners in the room, so they're going to have to design a model. But I do want to be having alongside that consultative groups with both adult victims, survivors and children, to whenever, as we develop a draft, that we bring it back, take their feedback on that and then come back in. So we will continue to ensure that their voices and experiences shape what the final sort of proposal is in that regard. If anything comes up in terms of anyone in the group thinking about, there's a really key body that's missing here in terms of the process, we will invite them along at that point. Your other question around how far embedded this is, and obviously I don't want to have to wait to a pilot either. I am hearing people talk about the report, which is positive, and that's it's hopefully an indication that there's change. I'm maybe going to ask Louise talk a little bit about the health side in RTI.
Yeah, so we have spoken to Department of Health officials, and obviously the Health Minister has asked RQIA to conduct a review of child court officers across the 5 trusts in family court cases, so which is really, really positive. We're also being made aware, and this is through our sort of preliminary work gathering together the Task and Finish group of some really passionate activist social workers who are looking at this issue themselves. And what we're hoping to do is that this Task and Finish group will form a sort of lightning rod where we can bring all this together and help it to build the model as well.
And I think that's great, because I think they've been stifled, because they've been a lot of the professionals have been stifled, because this is a system, and that's a system that we have to operate to, rather than doing what's right.
Yeah. And so there's opportunity for us nearly to be tested within as we're developing the Task and Finish group, if people within their area are able to start to do things. And again, whenever I think back to the referenced earlier, the family resolution pilot that the Lady Chief Justice that they're looking at, I'm hopefully going to be speaking to Judge Bagnall, who's leading on that, in a couple of, I said I'd connect in with her after she's up and running a bit. That's looking about trying to reduce the adversarial piece. It excludes domestic abuse cases, but I think that there may be learning from that we can then build in. So I certainly don't think we should be waiting but there does seem to be, there's positive kind of,
Yeah, there's positive
vibes
movement
in
in a lot of different pockets, and really it's about galvanising that.
totally. But it won't be fixed if we don't reform the whole thing, and I'm really conscious of that as well, because it's not about tweaking around the edges, it's about radically reforming that process map as to what you go through if there's domestic abuse allegation comes into the equation with this. So.
And I know it's quite difficult. Have you got a time scale in your head? I know obviously you're working towards getting it up by the end of June, but is it a year? Is it 18 months? You just don't know until you get started, or?
I would like us to have some sort of proposal within 6 months. They're all going to laugh when I say that, but we'll do our best. This shouldn't be rocket science, and the fact that it's a pilot means that we can adapt. We just need to get, there's learning from other places, so I suppose I just want to keep the momentum moving. I am conscious that though we'll be starting in June, we'll have summer leaves and things like that, but my term ends in March or in June next year, so this will be my pardon shot hopefully, but we hopefully will be a good way forward by the end of this year. I would be wanting to be, if you are going, what's coming out of that thing? There should be something by now, and if they're not, please be writing to us and comment.
Just one wee quick one, just final one, just in relation to the current system for children's voices to be heard. What is it? What is the current system?
You mean how our children
Or
work in at the
currently
moment?
their voices are heard in
So-
cases particularly with domestic abuse?
So it'll be up to the judge to determine whether a children's or a child court officer is involved. The legal professions involved in this report indicated that only happens in 50% of cases. Now that's an indication; it's not a qualitative stand-over figure. But that surprised me because I thought it would have been higher than that. And I think some of that is around resources, which is one of the challenges here, because what any pilot will need, what any reform model will need, if we're trying to capture children's voices at the outset, we need social services availability to be doing that work at the outset, which is a change to what we're doing now. So that tends to be how their views are brought in at the moment. And if they're not, the child's not directly spoken to, it's via the parents then that they hear back. Children's court officers, if they haven't spoken to the child, may speak to a school, but I think it's not missing anything.
And is there any, just one final one, any specific training that's currently available that supports professionals, whether it's a school teacher, social work, whatever, to be able to communicate effectively with a child, for a child to have its voice, particularly if a child has went through trauma?
There's different people do different things, yeah, and I suppose Louise written down there for me, toolkit. One of the things that came up in the pilot in the Pathfinder in England was they developed, children and young people developed a letter writing toolkit. So back when I was saying to Brian about particularly very young children, judges might write a letter to the child. The children and young people involved in Pathfinder in England and Wales have developed a toolkit for judges as to how do you communicate with children. So, I have no doubt there's anybody who will read this back or watching it will probably screaming at loads of different models that there are. But I think there's a lot of expertise, particularly in Northern Ireland. And, when I think the Lundy model that's referenced a lot in this is Northern Ireland. Like, it was developed, proposed, it's an internationally recognised model, and it was developed in our very own Northern Ireland. So there's we'll not be stuck for how do we do it. It's just the ability and willingness to do it.
Thank you.
Okay, Doug.
Thank you, Chair. Geraldine, Louise, thank you very much. I mean, it's fascinating, and for the length of time we've had you in here, you can see we're all really engaged in this. One of the things about going nearly last is that you end up covering ground that's already been covered, so apologies with that. But there's a degree of frustration I have here, and that frustration is when we talk about training, because we've been banging on about training for such a long period of time, whether it's police training, which isn't up to the required standards, whether it's the public prosecution service, which aren't as open as they should be about the training they're doing, or our judiciary, who are not doing training at all. And the Judicial Studies Board is the ones who mandate training for our judges. Why can the Lady Chief Justice not be told to create a module within the Judicial Studies Board and make it compulsory for the judiciary to do it. That's a quick fix. It's not a long, difficult one. This is a module. You will do it. Why will she not be as proactive as she should be in regards to that?
Difficult question for me, Doug.
Sorry.
I obviously, I'm not sure that the Lady Chief Justice has refused to do that per se. In terms of mandatory training for judges, there is some things that I understand they have to be trained on. And in England and Wales, I know that there's judges like ticketed, as it's called, to work on certain cases. So I do think that could be something that comes out of this. But in terms of recommendations around training, your point is well made. We need all the relevant bodies to have a level of training. What I would say, and I am aware that the Judicial Studies Board have had presentations recently from organisations like Women's Aid, Victim Support, etc. So I'm certainly seeing a greater involvement and engagement with the community and voluntary sector, and tapping into their expertise in terms of training as well as bringing in experts from other areas. So I definitely think that there's a piece of work to be done there. How do we ensure that anything will be mandatory? I suppose I'll go back to the legislation piece. I'm not sure legally whether can the Lady Chief Justice mandate other judges to go to training. I know the Judicial Studies Board pieces seem to be that it's whoever signs up, whereas regardless of whatever organisation, judiciary, PPS or not, police, the whole thing, there's certain requirements that I think must be mandatory, and this is one of the areas.
I totally agree. I think it was Connie that raised the fact is that they're not on the task and finish group. That's right, isn't they're not on it. I mean, that's key. That's a key failing from the judiciary, I've got to say it. And look, we can give leeway right across the board when we know people are busy, but to deliver what you want to deliver, that's key, that they should be sitting on that. And it's not about you will brief them on the outcomes. They need to inform the outcomes. They need to be in there. So I'm frustrated about that, to be honest. I'm also frustrated, if I can, Geraldine, about the legal aid waiver. I'm just looking at the figures for the legal aid waiver. What's going on that so many are out of scope or withdrawn? I mean, there's more out of scope and withdrawn than there is approved.
Okay, so I share this frustration as well. The legal aid waiver on paper sounds fantastic and sounds like we've made a really great step forward. The reasons why there hasn't been the uptake for it, I think, are multiple. Some of it is lack of awareness, some of it is the complexity of the process, the threshold that needs to be passed. I think we're on a journey in terms of seeing that improve through the Access to Justice review, so there certainly has been proposals put forward as part of that in terms of the level of information that needs to be provided. In terms of the legal aid available for it, it has to be worth the solicitor's time to complete. Otherwise, it's going to immediately be disregarded. If they obviously are self-employed, they're not volunteering their time. So if it doesn't pay them to actually complete the form, that's an issue. And I think that's been recognised and is being looked at. Also, the complexity of it and the level of information they're asked. From my perspective, and I know that this may be seen as outrageous, but where there's any domestic abuse allegation, I don't think that. I think we should just do legal aid, regardless of whether somebody's means are. I think it's if someone has been a victim of domestic abuse, we should remove any potential for litigation.
And you get that sense, don't you? Because when it's called the legal aid waiver. And actually it's not. It's a damn big process that you have to go through, and I mean it's frustrating.
It involves an awful lot of complexity. Like even if someone's ever had a Paddy Power account where they put do a flutter on the horses or whatever, all these things have to be looked at and submitted as part of it. It's such a comprehensive level of information that is needed in order to pass a threshold, and it's off-putting for not only victims, but then the level of work that needs to be done by solicitors. But I do think that is recognised and is in hand, but it's work to be progressed as part of the Access to Justice review.
And can I just ask, Gerald, did I hear you say you recently met with a domestic abuse victim who's been in the family court process for 10 years?
This morning, yeah.
So explain that to me. How can that be right? 10 years? Is there somebody not the victim? Is there somebody gaming the system here?
Oh, and
Not the victim, but let me just say
add
that.
detail. But it's the length of time the cases taken, obviously delays in proceedings, being brought back with new applications, and that's the
10 years.
10 years.
10 years.
And it always hangs over people until the child gets to kind of adulthood, because you can always be brought back then, you know, you're living with that potential fear hanging over you that someone will lay and bring you back. And don't get me wrong, parents who want safe, meaningful contact with their children is to be welcomed. What we're talking about here, and I kind of I'm re-emphasising it because I want that to be really clear. What we're talking about here is domestic abusers. Domestic abuse. And people using the system.
Yeah,
so this system needs to be reformed in order to eliminate that potential, and certainly at the very least reduce.
Because in that instance, we could have children who were 8 when the process started, who are now adults. 18. I mean, I think it's scandalous. Another very quick question for you, if I can: have you come across anywhere where there's been extremely young abusers? In other words, the domestic abuser is using the children to be a surrogate abuser. Have you ever? Do you understand what I mean? Have you not come across? But where you have the abuser who's using coercive control over their own children to abuse.
We do hear examples of victims saying where potentially through contact the abusive parent is using contact to feed information and messaging back to the non-abusive parent via the child, so the child is nearly being used as a tool in the process to help facilitate that. Sometimes that can be done subtly, and that's one of the dynamics really of coercive control, how people can bring in what on the face of it looks quite innocent, but when you have the broader understanding of the dynamic between those partners or ex-partners at that stage, what messaging that can be given, and also how other family members can be brought in to facilitate that as well. So that's a dynamic that again is part of that, understood as part of that training around coercive control.
Yeah, and you can see the difficulties here, can't you? When young kids are actually becoming the abusers because they're being coerced into it, and it's particularly if you're going through the family court proceedings and they're the ones who are unwittingly perpetrating, continuing on with those. Listen, thanks very much. Thanks, Stuart.
Thank you very much. Just one wee quick question, because we are struggling for time, Geraldine. How can you reassure that, and we all recognise this is the direction of travel, first of all, but how can you assure that there's nothing in this movement going towards where we need to be that won't make it easier for people, whether they're domestic violence perpetrators or not, to practice parent alienation? So, obviously, even the term parental alienation is debatable. Does it exist? How do we define it? And I think it's been a key aspect of, particularly in England and Wales, you see it manifesting a lot. In this research, you'll see it mentioned as well. What is really important is that there is appropriate guidance and training for the judges, social workers in relation to what alienating behaviours might look like. And there's been guidance developed by the Family Court in England and Wales in relation to that, which disregards the concept of parental alienation and advocates against the risks associated with that and sort of pseudoscience potentially around that, but does recognise that in certain circumstances someone may be using the child, I suppose, and alienating them as part of that abuse. So we can't disregard that. So that's where it's important that there's the training. My understanding is that the Shadow Family Justice Board here are also developing training in relation to that. So I think how you try to mitigate against it is, it's nearly in any new model as much as it is in the current one. We need to ensure that people have an understanding of what that is and how that looks like, and that there's guidance for how to respond. How can we have an understanding of that and train for that when it's still disputed in many quarters? Well, I think it's the actual parental alienation as a syndrome is the disputed piece. Is there
an indication that a parent can try to use a child against another. You know, I spoke to judges about this about 3 years ago, and I was told, well, that's like as old as motherhood and apple pie. You know, it's inevitably going to happen in some circumstances, and we're always going to be alive to that. I think what unfortunately has crept into our family court system is that has been used as nearly a litigation abuse response, so that when someone says that there's domestic abuse, that then there's a counter allegation of parental alienation comes in, albeit in Northern Ireland we tend to use the word implacable hostility more. And that is one of the reasons why there's a fear from some victims around even raising it, and why some solicitors, I have been told, have advised against raising it, because that will then get into it. And one of my hopes, Chair, is that through a system that first and foremost deals with the allegation of domestic abuse, we can remove the potential or reduce the potential for then there to be the counter allegation of parental alienation, or whatever it may be called or presented as by the individual party. So if there's any allegation of domestic abuse, that's determined from the outset. And then if there's a finding that there is, and then there's a counter allegation of parental alienation, implacable hostility, whatever, alienating behaviours, whatever it may be framed as, then that is being judged through that light. And I think at the minute, in some of our cases, there's an awful, and it's back to that adversarial piece, a lot of mud is being slung from either party, and whenever we're alleging domestic abuse, we start with that, we start with the child, and we work from there.
Okay, thank you very much. That was very good. Sorry for that took so long, but it was a very informative session, and all of the members were very, very interested in this piece of work. So thank you very much for that. I wish you a good day. Thank you.
Thank you very much.
Okay, we did have an ask there from Ciara just about chasing up the review of the Lady Chief Justice.
It would be reviewed in 6 months.
Yeah. Okay.
Section 12.1 of her.
There we go. Okay, so
the
everybody
last
happy
paragraph.
with that then? We request that, find out where it's at?
Yep.
Okay, thank you, members. So, agenda item number 5, Justice Bill Taxation Reform, the new clause 27A, Law Society of Northern Ireland Oral Evidence. Can I refer members to page 161 of the meeting pack, and also then to the table pack for the relevant papers? Can I remind members that last week the committee heard oral evidence from the Bar of Northern Ireland on the Justice Minister's intention to bring an amendment to insert a new clause 27A to the Justice Bill. The committee also felt it would be helpful to hear the views of the Law Society on this taxation reforms in the new clause. So can I inform members that the witnesses providing evidence today on behalf of the Law Society are Owen McKenna and Janice Spence. So you're very welcome here. Thank you very much for your attendance. Sorry you had that wait. There. Can I ask you to open up, please, and we'll kick off. Thank you.
Yes, thank you, Chair. Good afternoon. Thank you for the invite to attend the committee today. I am Owen McKenna, Junior Vice President of the Law Society, Chair of the Access to Justice Committee, and a legal aid practitioner. I'm joined today by Janice Spence from the Family Law Committee and also a legal aid practitioner. Hopefully everyone has had an opportunity to see the formal response from the Law Society, and that can be considered in due course, I imagine, at everyone's convenience. We have some related remarks, if we may be permitted, please. And I will focus my remarks on the taxation process and the early rate. Janice will speak about uplifts and some other angles. When we appeared before the committee last May to speak on the Justice Bill, we raised major concerns around Clause 28 of the Bill. We therefore support the removal of this clause from the Bill. By way of background, taxation in legal cases involves the independent assessment and determination of costs associated with those legal proceedings. Taxation applies for both private paying and legal aid cases and is a well-established feature in the justice system. In legal aid cases, the Legal Services Agency considers applications and authorises specific steps to be taken by solicitors, barristers and experts through the grant of a legal aid certificate. Accordingly, any work undertaken will have been approved by the agency. At the conclusion of the proceedings in the case, the judge makes an order for taxation and the case is then referred to the taxing office for assessment. The current taxation process is governed by Order 62 of the Rules of the Court of Judicature. Within this process, solicitors are required to submit a comprehensive bill in respect of a case to the taxing master, who then assesses and determines the amount of legal aid costs to be paid. The taxing master plays a central role in the taxation process. As an independent judicial officer, the taxing master is subject to established standards, court rules, and is ultimately accountable to the Lady Chief Justice. Importantly, the taxing master has a legal duty to protect the legal aid fund, as do solicitors. Solicitors record all work and expenses as the case proceeds. When submitting a bill to the taxing master, solicitors prepare a detailed account of the work undertaken by them and any disbursements incurred. To assist with preparing the bill, solicitors often engage a specialist, known as a cost drawer, who drafts a detailed bill of costs. The bill of costs details on a line-by-line basis every step taken in the case, including all attendances with clients and their witnesses, all correspondence, all telephone calls in and out, the instruction of experts, consultations, attendances at court. Each item listed relates back to the file. Vouching documentation is also required to be lodged in relation to any disbursements and court orders made. In assessing the bill, the taxing master considers a range of relevant factors, including, for example, whether the hourly rates claimed are applicable, whether the work claim is covered under the certificate, whether the number of hours marked are proportionate and properly claimed in a case, and whether the costs claimed are reasonable. The taxing master also considers whether the complexity and seriousness of the case merits an uplift. The Society considers that the assessment of solicitors' costs is therefore thorough, transparent, and an evidence-based process. The current system also contains other robust safeguards. For example, the Legal Services Agency retains the right to intervene and can make representations. The agency also has a process in place for the flagging of higher costs cases and liaises regularly with the Office of the Taxing Master. There is also an appeals mechanism in place through a possible review by a High Court judge. Moreover, the available data does not provide any strong evidential basis for reforming or restricting the current taxation framework for solicitors' fees in legal aid cases. Data held by the Department of Justice shows that solicitors' remuneration has only increased on taxation by 7% when adjusted for inflation between 2016-17 and 2023-2024. In contrast, council's taxed remuneration increased by 200% when adjusted for inflation during the same period. Against that background, we consider that there is no need for the current system to be replaced or amended in relation to solicitors. Turning to Clause 27A, the proposal to set legal aid rates through secondary legislation for High Court and Court of Appeal proceedings and to require those rates to be applied by the taxing master represents a significant change. It would transfer the setting of the rate from the independent taxing master to an administrative function of the department, thereby restricting their role. There is limited information available currently on how rates would be set within proposed remuneration orders, including what factors would be considered to determine the rate. It is also unclear whether the current hourly rate, determined by the recent working group on the solicitor's hourly rate in 2025, chaired by High Court Judge Mr Justice McAlinden, which considered an expert report from BDO, would be respected. If a revised framework is to be set by the department, fees to be applied within the taxation framework should be set at an appropriate level to reflect the real cost of providing legal aid services. This must include consideration of factors such as time, skill, the level of competence of persons providing those services. Also, rates set should be reviewed frequently, having regard to factors such as inflation, other statutory cost increases, economic conditions, cost of living and cost of doing business increases, as well as changes in practice and procedure. This should also include consideration of ensuring reasonable remuneration for solicitors given the growing costs of running a solicitor practice, as those solicitors try to ensure equal access to justice for all. It is important to note a consequence of the proposed change to the taxation process, which risks creating a system in which two different hourly rates may apply. This would introduce inconsistency and uncertainty. In practice, it may discourage solicitors from undertaking legally aided work and may result in a two-tier system of access to justice. I will now hand over to Janice Spence, who will speak on uplifts and some other issues. Thank you.
Hello, good afternoon. I just wanted to start by saying that I am primarily a family law and matrimonial law solicitor, and I have been doing legal aid work throughout the entirety of my career. Probably less so now than I've ever done because of the difficulties involved in undertaking that type of work, and I wouldn't be unlike very many of my colleagues who would find themselves in the same position. So I just wanted to set that out as the framework as to what I want to say. So as mentioned by Owen, part of the taxing master's assessment role is considering whether the complexity and seriousness of the case merit an uplift. Now, uplifts are an essential mechanism for ensuring fair and reasonable remuneration in complex and serious cases. And any family case which the majority of the taxation master will deal with, they are serious cases. They're in the High Court for that very reason. So they fall into this space. A rigid fixed rate system does not accurately reflect the reality of legal practice. Cases can vary significantly in respect of complexity, volume of documentation, novelty, and the level of work required. Without the ability to apply the uplift, there is a real risk of undercompensating solicitors who are undertaking the most demanding and complex work for often the most vulnerable in society. This would have several consequences. For example, firms will struggle to recover the true cost of complex cases. Practitioners will be de-incentivised from undertaking these types of cases, and the sustainability of legal aid provision will be undermined. Ultimately, this creates a real risk to access to justice. The cases that I do are for parents or indeed for children who are at real risk of loss of their parent, loss of their family, or loss of their children. I deal with cases of adoption, freeing for adoption, where issues such as drug abuse, sex abuse, physical abuse, prostitution, alcohol misuse are very often most prevalent. It's also particularly significant in the context of the solicitor profession in Northern Ireland. Local solicitor firms supply vital services to members of the public, and they are an essential part of the community. They enable access to justice for the most vulnerable in our society. Around 90% of solicitor firms in Northern Ireland have four or fewer solicitors, including just over half who are sole practitioners or sole principals. Like many other small businesses in Northern Ireland, solicitor practices have significant overheads, including, but not limited to, salaries, employer contributions, rent rates, service charges, cleaning costs, accountant bookkeeper fees, training costs, IT technology, etc., and there's a detailed list set out in the papers. We, as those solicitors, and I have my own firm, as does Owen, we don't have the capacity to absorb underpayments in complex cases. We have real world issues. There's a lack of staff in Northern Ireland available. We're paying higher compensatory rates for staff in their payment. We obviously have difficulties in recruiting staff. We have even higher utilities this year with electric, oil, petrol, etc. So any restriction on uplifts would therefore have a disproportionate impact on the viability of, I would say, these practices, and would accelerate the emergence of legal aid deserts, where individuals are unable to access representation. And we are already seeing this on the ground. We are seeing areas, particularly rural areas, where solicitors aren't able to do legal aid work at this stage, and people are left without representation. So for those reasons, the Society considers that enabling discretion by the taxing master to consider uplifts is an important and necessary feature of the current system and should be preserved. Finally, it's unclear how the new proposals would improve accountability or cost predictability for legal aid cases. Legal aid is unfortunately a demand-led area. Costs fluctuate depending on the number of cases within the system. Structural changes to remuneration mechanisms do not alter that underlying reality and risk introducing unintended consequences in a situation where there does not appear to be a clearly identified problem. So that concludes our presentation, but of course we'd be happy to take any questions.
Okay, members, I'm going to warn you here, we had a really long session last time, so I'm going to ask you to be concise. I'm going to ask the presenters to be concise in their answers too, if you can. I know this is a very important issue, but it's more technical than the last session we had, so please don't have any statements. We'll leave that for the Assembly Chamber, so just questions. Brian?
Okay, I'll get straight into the chair. Well, thank you for your attendance, and obviously we had the Bar Library here last week and making some similar issues. The point I made to them is that Clause 28 was quite long and difficult to understand, speaking for myself. 27 is extremely brief and essentially just says that the department may make provision for how the taxing master can determine remuneration. So you're obviously reading into that this could result in a reduction. So they also accepted that there are actually different scales for how rate. It's not just at one stage they were saying, oh, it could be just counting up the number of hours, but I think they did accept that there was actually different scales potentially for different types of work. So my question is, what have you heard beyond what is in this brief 27A clause? Is it conjecture on your part that you're just fearing the worst, or have you heard anything more definite? And I would add the other comment I made last week that as elected representatives, we do believe in accountability for public finances. You know, I think there has to be some accountability and some system in place, not just an unregulated system. You know, and that is a general principle for us. But similar to NHS dentistry, the professionals delivering a service needs to be financially viable for them. Sorry, Chair, probably gone on too long. So have you heard more, or is it conjecture on your part and fears of the worst of what could happen?
I think it's, from my point of view, it's conjecture on the part of having dealt with the Legal Services Agency now for 20 years in relation to issues such as this, that we can only assume that there's going to be some cost-cutting exercise. There's a lot of discussion in the papers about the reason why some control has to be taken over the costs that the taxing master is dealing with. 75% of his work is legal aid work. But I think that what is very clear to us is that there hasn't been a massive rise in relation to solicitor costs within those periods that Owen set out. It's 7%. Where I have seen the bigger rise in relation to costs is in the likes of family brief fees for counsel, for senior and junior counsel. I suppose what is being proposed is that we would remain on the fee-based system that we have always been on. We charge an hourly rate, and that would continue. Whereas for the bar, the change is that they would come off their brief fee scheme and go on to an hourly rate. And what we would say is, why not? That's what we do. And we have to account for every hour, every letter, every phone call, every consultation, and that has to be set out in a bill of costs.
Would that not still happen though?
It would still happen, but the fear is that there would be a set fee which would be set by the department, which would not sit with the same fee that we have just recently got the rise in. Our basic fee now has risen to £155 per hour. It was 102, but it was raised after 11 years. So it took into consideration there should have been incremental raises every year, and it took that into consideration. There seems to be a fear now that because of that rise, there will be an upward trend in relation to the claiming of legal aid costs, when the reality is that all that 155 is taking into account is how difficult it is to run a practice. The 155 is the fee that you get paid in order to, I suppose, isn't that the phrase, wipe your face? The uplift, which I was talking about, is
obviously
where...
that includes all your practice costs.
Yes, that includes your insurance, everything, absolutely everything. And it's all set out. The uplift is what we would get in relation to profit, and currently the master applies the uplift as he sees fit in relation to the complexity of the case. The master has the benefit of seeing your bill of costs, which very often runs to 15, 16, 17 pages, and he is able to assess, as a judicial officer and as a previous solicitor, he's able to assess the level and complexity of the work involved, and then he applies the uplift, which starts at 50% and can go up to 100%.
Yeah. But I'm still not persuaded at how this clause in itself will change any of that.
We don't know what it will do.
Yeah, it's the uncertainty.
Yeah.
That's part of our complaint in the response, and even today, which is, why don't we have the full picture for the committee, for the Assembly? And at one of the previous Justice Committee meetings that I was at, it was described as a power grab by the department. And it's the effect, it's the order of this that objectively doesn't look great, in my view. And in terms of what would come next, yes, there's an element of speculation, but we've just lived through the criminal legal aid review. There's an accelerated review that has just reported, and during the discussions in that area, the reform has been poisoned to an extent by the refusal to accept the legitimacy of the hourly rate. And this updated hourly rate is a break-even rate. That doesn't allow for any profit. It's the uplift that allows for there to be a profit. So we have worked with the Department of Justice collaboratively, positively, largely, in very strained circumstances, because the solicitors have to fight their corner and urge remuneration levels that allow them to keep their doors open and employ the staff and help society and their clients. But at the same time, understandably, the Department of Justice, everyone has to look to the value for money point. Everyone has to look at the lack of resources that are there, for all services. So it's a difficult circle to square, but it's the order of this that is part of our complaint, and it's also the undermining of the taxation process as is, because on the basis of this clause, yes, it's better than what was there before, but even in your question today, there is an inherent criticism of the current system, and as solicitors, we think that that system for solicitors is onerous, and also the role of the taxing master is onerous on that individual also. So whenever that system's working well for solicitors, the question is, why change it? And particularly in the context where we don't know what comes next with any certainty. Okay, thank you.
Okay, Aoife?
Thank you. I will be quick. So we recognise that the Law Society and the Bar has expressed serious concerns around the previously indicated legislative change under the now redundant Clause 28. Do you have any concerns regarding the proposals around legal aid taxation within the newly drafted Clause 27A?
I suppose those concerns we've just really set out. We don't know what the 27A is going to do down the line. It's the horse before the cart, in effect. And that, because of the dealings that we have had, as Owen has said, gives us cause for concern. We also are, because the LSA is so heavily audited and so heavily now checked, and there has to be accountability when you're spending public money, we see the impact of that every day in practice. Just this week, solicitors were told that they would no longer get a small 5% uplift in relation to travel and in relation to waiting time, because the auditing of the system showed that that was never legislatively set out. So we are very much aware of whenever cuts happen, they're at our door, and you're having to make it. I mean, effectively what we do is, my firm carries legal aid work. We carry it. We do it because we're a local firm in a local community, and we can't turn legal aid work away. But I do that on the basis that I charge very often twice and sometimes 3 times the hourly rate in other cases and other types of work that I do. So I think that if you're in the privileged position to be able to do that, which I'm in, a lot of my colleagues aren't. And as Owen says, we need to keep the doors open. We need to keep people the whole idea of access to justice is to keep it open for everyone, as well. You know, the other concern I have is that, say for example, the department did put in a fee, and the fee was 20% lower than the fee that you would get for doing the same type of work. In the work that I do largely matrimonial. Women use proportionately legal aid more in matrimonial cases than men do. If you have a system then where solicitors are saying, I don't want to do legal aid matrimonial work anymore, women are going to be indirectly discriminated against in relation to that, and will find it more difficult to find a solicitor who will act in their behalf in relation to matrimonial matters of finance. And there is already enough discrimination in that area without heaping that on as well.
Thank you, it's very useful.
Thank you.
Just a quick one, just before just the question. So you've said you're questioning why change it. You're questioning it could create a two-tier system. You don't see how it can improve accountability or cost predictability because it is demand-led. And what we really gravely need to be concerned about is the legal aid desert, and we've been talking about that for a good few years, and we've been talking about that particularly in small towns and villages. We are losing our solicitors. We don't see the recruitment of young people going into the profession because of that very case. So it's quite damning, particularly leaving the legal aid desert and ensuring that everyone has equal access to justice. So this is really critical. Given that we don't even know what it is these changes could be, so we're all in the limbo, everyone. And the department's stated intention is to make the necessary remuneration orders by the end of this current mandate. So basically, within less than a year from now, and no one here, taxing master, yourselves, the profession, us as members of the committee, and I've been asking here for 2 years, what is it you're changing it to? And none of us know. So, do you think in the next year there's even enough time, based on various relationships and consultations and engagements you've had with the department over the years, that there's enough time in a year to be able to know what it is it's getting replaced with?
I was involved in a starter, for want of a better description, in this world generally, because the Department of Justice have a massive amount of information on how these taxation legal aid cases have worked through the system, and the majority of that information has come from solicitors' bills, as we have outlined, and that has been analysed for many years now. And there was a significant amount of collaboration on some of those test areas about, is there a new way that we could come up with a new remuneration scheme that would replace the existing taxation world in that area? And we were able to go so far down the road on some of those more minor elements, but again those stopped before there was anything agreed. But I imagine, on behalf of the solicitors and the Law Society, we would certainly engage in any process that looked at everything in a rounded way, because we can always improve any system.
Yeah.
But what we would say in this world is, for solicitors, this system should not be criticised as much as seems to be at the root of this move, because it's hard to imagine a better system for assessing legal aid remuneration, because you have a senior judicial figure managing that process from start to finish after the case concludes. At the very beginning, you can't actually start the process until the legal aid body grants a certificate. And then the solicitor, in between times, has to keep contemporaneous notes, line by line, minute to minute. So the amount of data capture that's ongoing there, and again back to the criminal legal aid review, when we worked through that with the Department of Justice and external bodies, everyone looked back to solicitors' taxation and bills and said, wow, look at the amount of information there. We understand what you're doing and why you're doing it. But ironically now in this clause, that's been effectively nobbled before we see what comes next.
No, that's fine. Thank you.
Okay, thank you very much. I've read your submission just as you were talking there, because it did come in quite late for us. And you lay out your concerns very, very well, and they're detailed. You may be a wee bit diplomatic with regards to your actual final outcome, and that is, if you had the privilege to vote for 27A, would you vote for it?
At this juncture, absolutely not.
Okay.
Because if I was being asked to vote in anything, I'd want to understand the full repercussions of that vote.
So that was my next question. Is it on principle around the independence of the taxation master, or is it more about the fact that it's skeleton?
I think we have to respect the role of the taxing master and previous taxing masters, the overall taxation system, but also we have to champion what solicitors have been doing for years on this. You know, there's a whole debate in terms of legal aid remuneration around standard fees, time-based fees, and we've lived through the years, if not decades now, of, oh no, time-based remuneration doesn't work, let's get a composite fee, and that's better. And then ironically, the department and legal aid don't seem to like that to a certain extent down the line, and they say, oh, actually, let's get a lot more data and information. Just giving a standard fee isn't actually working out. So you keep going around in circles. And ironically, taxation for solicitors seems to be very effective on all fronts.
With the taxation process, I'm sure, I know that you spoke to the taxation master and the Lady Chief Justice was there. The taxation process is onerous. You know, we give over our file to an independent cost drawer, and whilst I appreciate that we pay the independent cost drawer, we don't get that money back from legal aid. So we don't. So it is another outlay. Very often it's £1,500, £2,000 of an outlay, which is taken off your profit from the case as well. So that independent person pulls your file apart and puts together the work that you have done. We're not allowed to submit. We all have systems like ALB, which are case management systems. We can't print those case management systems off and hand them over. We have to show the physical file, has to be shown to the cost drawer. So the truth of the matter is in the papers that you produce. So the taxation master is actually getting the work that is being done, not all of it, because when I lie in bed at night thinking about Mrs. X, who I'm really troubled about, I'm not writing down that I consideration 15 minutes thinking about that case, but what you're getting is the snapshot of the work that's being done on that case on a contemporaneous basis, and that I think is the fairest way to assess how public money is being spent. And that's why I would say that, you know, the paying us in relation to 155 in relation to baseline cost is grand, but the taxation master then, who has that skill and who has submitted his own, because he's a solicitor, he's submitted his own tax cost basis before, he has that skill and ability to know, well, I know the consideration would have been given to this case in this way, this way, this way, and he knows what percentage then to apply to it. We have the very onerous task of setting that all out. And I think it does work, and it works as well in the private law sphere, because we are also subject to taxation if you disagree a bill with a private law client, and it's a very vigorous system there where someone's able to go and challenge your bill as well. So I agree with Owen, why fix what's not broken?
Patsy, you want to comment?
Thanks very much, Chair. Just looking through the stuff, can I ask you the legal professionals, I'm looking at the wording here. The department may by order make provision about the payment of remuneration by the department persons who provide civil and legal services. And then it goes on to talk about remuneration orders. Well, clearly you're saying you know the system at the minute. I don't know if it ain't broke, why fixed. I don't know. That's me, because clearly you're the ones that are working with it. But would it be fair enough analysis from your point for ourselves as elected representatives? We don't know either what this potential remuneration order would be. Fair enough analysis to say we're being asked to buy a pig in a poke.
Well, I wouldn't certainly buy this product at the Mart or wherever.
You know what I mean by that, don't you?
Yeah.
Aye. Okay, no, but that'll be a fair enough resume. Okay, thank you. Thanks.
Your use of judicial language, Patsy, is we're all trifled by that.
Okay, thank you.
Okay, listen, I think that's quite clear. Thank you very much for your presentation. There's no other members who have indicated to speak, so thank you for your time and sorry for your wait.
It was very interesting. I am a practitioner in the Family Proceedings Court, so you probably saw me bristle quite a few times. Not all.
You nearly got a double presentation.
You very nearly did.
Back.
Yeah. I would be very happy to come back, and I did a lot of work on the waiver, so
good.
All right,
I would be very happy to come back.
Thank you. Thank you very much. Okay, then, members, pushing on. Agenda item number 6 is the Justice Bill Restorative Justice Accreditation Process Outcome. Department of Justice Oral Evidence. Can I refer members to page 165 to 239 of the meeting pack for the relevant papers? Can I remind members that following recent consideration of an update from the Department of Justice on the outcome of the new Adult Restorative Justice Accreditation Process, members agreed to request oral evidence from the Department on the process to further clarify a number of matters on the robustness of the process. This is within the context of members considering an amendment to the planned Ministerial Restorative Justice Amendment to require Criminal Justice Inspection NI to conduct pre-accreditation checks of prospective providers. So can I inform members that providing evidence today on behalf of the Department is Veronica Holland, Deputy Director of Reducing Offending Division. Can I welcome Veronica to the meeting? She's no stranger to this committee and we've enjoyed her presence a lot. So could I invite Veronica to make an opening statement, please? Thank you.
Thank you, Chair. Much appreciated. Conscious of time for members, I'm happy to do a brief opening statement or go straight into questions, whichever you would prefer. Either is good for me.
Okay, could you do a concise presentation?
Yes, when I was outside, it was only 5 pages, but I've taken 2 out. So yeah, I'll certainly do the shorter version of it. So
professional that you are, Veronica. Thank you.
So over the last couple of years, I suppose there's been a range of work being progressed in relation to the restorative justice, the new accreditation process, the way in which it is operated. We had a revised protocol in 2023, and under the auspices of that, the range of work has been taken forward. So it's included setting training standards and also designing a new detailed practice standards and accreditation framework that was published in October last year, and that is governing the new accreditation process. And provides for a number of safeguards in terms of the process going forward. That documentation and the process that we're adopting clearly sets out the expertise, training and experience that service providers must have in order to provide restorative justice departments as part of the criminal justice process, and it also sets out practice standards plus key skills, knowledge and competencies that are required by practitioners. This also includes a requirement to uphold the rule of law, to adhere to human rights standards, and to work in partnership with all criminal justice organisations, including the police, as part of this process. And I suppose that's intended to provide a reassurance about both the experience of practitioners and the quality of the service that's being provided. A key difference under the new system is in relation to the accreditation of organisations as well as practitioners. So previously it was organisations that were accredited. So under the new process we've accredited 7 organisations and there are 26 practitioners accredited. 20 of those practitioners would be accredited to deliver criminal justice services. The others relate to level 1, which is below the criminal justice system threshold. And then in terms of the application process that we had went through in relation to that, there was a robust protest gone through with the protocol lead. The applications are then considered by a 3-person panel and then considered by a senior official in the Department of Justice before decisions were reached in relation to those. And as part of that process more generally, we've also provided 6 days training for the practitioners in terms of the restorative justice conferencing process, which really I suppose is one of the key aspects of this process. It's a move to restorative conferences which are akin to those that are used in the youth justice sphere rather than I suppose lower level restorative practice processes. And then in terms of some of the key differences in terms of the new process compared to the old, as I say, we would be of the view it's a more robust process in terms of the level of skills, experience and training that must be demonstrated by those that are applying for accreditation. And that has to be evidenced in terms of the skills that the individuals have, their experience, the training that's been undertaken. Each accreditation level, and there are 3 levels, have clear, distinct criteria and evidence requirements associated with those. So it's a tiered accreditation system which is commensurate with the competency and experience of the practitioners. Applicants also had to submit a case study with evidence of restorative justice interventions that they had undertaken, and there had to be a demonstration, a proven track record of working with criminal justice agencies, including the police, as well as a commitment to operate within the rule of law and to continue with that as part of their accreditation by the department. That accreditation is reapplied for every 3 years. We wouldn't have had that process in place previously. And as I say, the focus is much more on restorative justice conferences rather than restorative practice under the new system. The department has also set out very clear requirements in terms of key performance indicators and monitoring that will be associated with the various organisations and the practitioners working under them. So that includes targets relating to the timeliness of contact with participants, the time frame from preparation for the Restorative Justice Conference to the outcome of that and the agreement being put in place, supervision of that agreement and any actions that are arising out of that, participation levels, satisfaction levels, as well as the submission of quarterly and year-end reports to the department, which will cover the KPIs and the monitoring that we've set out in the documentation associated with this process. And we'll also have quarterly governance meetings with each of the accredited organisations and regular stock takes with the practitioners as well. The other thing I was just going to touch on, probably not so much, well, a difference I suppose in practice, but not necessarily a difference in terms of the legislation, is in relation to the SIGINI inspections. So for both the current legislation and the new legislation, the provision is in relation to SIGINI may undertake an inspection. There's no obligation and I suppose no kind of requirements in terms of when that was done. Previously it would have been prior to the accreditation of organisations under the new process. It's intended that would be an accreditation an inspection by SIGINI once the organisations and practitioners are operating. And I think for both SIGINI and the department, we were of the view that it was important that they inspect and review the work of the practitioners and organisations once they're in place and operating, rather than through a one-off pre-accreditation check of an organisation's processes. And I suppose the rationale and thinking behind that is that the assurance that the process that we've put in place is robust and that we're getting the necessary assurances in terms of the individuals that are going to be providing these services. And I know that SIGINI have previously advised that they're of the view that they shouldn't be seen as the last hurdle before accreditation, rather there needs to be the assurances about the process itself. So as I say, we would be of the view that SIGINI's involvement in terms of reporting on the operation of the organisations and the practitioners is more appropriate when they have something to report on, when that work is in practice, that they can then advise the department in terms of any changes that may be needed, processes that needed to be tightened up, etc. We would hope that there could be an initial inspection potentially commencing during the second half of the 3-year accreditation period. This would then be followed up with a follow-up or progress report during the second period of accreditation. And I suppose the key thing in all of this, and from a SIGINI perspective, is that the approach that is taken towards our inspections is very much a risk-based approach that, given that there are limited resources, that those are effectively targeted as appropriately as possible, and as I say, on a risk-based approach where deemed necessary. So that's just kind of a quick overview in terms of kind of the key elements of the new scheme, and then obviously I know the committee have an interest in that SIGINI aspect.
Hey, thank you very much for that. I suppose I'll go straight in. Can I ask then, there was a fear or concern from some of the providers at the very start of this process, and some were led to believe that level 3, the advanced level, may have been unattainable for some or a lot of the applicants. But that hasn't been true.
That hasn't materialised. So I suppose in terms of the 26 that we have, there's 6 at level 1. And apologies if I get these figures the wrong way round, but I think it's 11 at level 2 and 9 at level 3. Yes, 11 at level 2 and 9 at level 3. So there's a good kind of spread in terms of the levels at which practitioners are accredited.
And there was a lot then who had applied for a level 3 but then fall into the level 2 category.
Yeah,
and that's the level granted.
Yeah.
Does that then suggest to you that there's a certain confidence in the robustness in the system?
And I suppose in terms of, I can't remember the numbers exactly, I think we had between, say, 68 that applied for a certain level of accreditation, and it was a lower level that was granted. But yes, that was really, I suppose, reflecting what the sense was in terms of what was being demonstrated in the application form, whether or not it met that higher level. You know, so, and we would expect the likes of those individuals that, you know, as they go through this first 3-year period, that, you know, when they reapply, in all likelihood, you know, they hopefully should be able, at least some of them, be, you know, reapplying and gain that higher accreditation.
And for someone to fall down a level, was that purely on their application form? Was that the written piece, or what made the difference?
It was based on the evidence that was given through the application process. So it was, you know, so there were a number of aspects that they had to go through and demonstrate in terms of what their experience had been, what their training was. You know, a range of things in terms of kind of their practice, as well as the provision of that case study to kind of demonstrate, you know, where they are at in terms of their restorative practice experience, the skills and expertise that they have. So yes, it would have been on the basis of the written evidence that was provided as part of the application process. And
given that written evidence is written by the applicant, was there any way of independently verifying that information?
As part of the process, we had each of the individuals in the organisations, the Restorative Justice Protocol lead had a brief discussion with them, and a couple of questions were asked to each of the practitioners. You know, so that was an additional part of the process.
And are you happy enough that was robust enough?
There's probably, looking back at the process, I think there's things that we would probably do different the next time round, and I think that's not necessarily in terms of there being anything amiss with the current process. I think it's more just there are things that we learned, things that we would do differently. I think both in terms of the application process, probably in terms of the training, but I think just really, you know, refinements that we could make to try and further improve the process. And I think what we'll also want to do as part of the process going forward is to get feedback and input from the practitioners themselves in terms of, you've obviously went through this process, is there anything that you would do differently, is there anything that you would want different in terms of kind of the training that's been provided to them, in order to ensure that they can best, you know, you can deliver the best service possible.
Everyone who applied got accredited at some level.
There was one that didn't, because they didn't provide follow-up information that the department had requested as part of the accreditation process, and then there were a number of applications that were withdrawn.
Right. Okay.
And I suppose the main thing really was the number that it was probably the main kind of distinction in terms of what was applied for and what was granted was in relation to the level of accreditation. But by and large, those that applied were accredited. Just a number, not necessarily at the level it asked for.
I'm just going with the table that was supplied by the department, reading across all of the lines. There seems to be, when you add up all the number of applications, there was a level granted to every one of those.
That case has possibly been noted in that table as a withdrawn, because they didn't submit what was needed.
Right. Okay.
If that makes sense. So apologies if that isn't clear in the table.
Okay.
No, it's not included.
It's not included at all. But can I ask then, is level 1 a catch-all basically?
Level 1, I suppose, is those that have, you know, a certain level of experience in this field. They're not necessarily dealing with criminal justice cases. There would be an aspiration that they would want to be dealing with those cases in due course. So it's really, I suppose, the initial step into dealing with cases before they reach the criminal justice threshold. Okay.
You say in the paper that accreditation will apply for a period of 3 years unless practitioners' circumstances change. What circumstances would you foresee?
For example, if an individual left one of the accredited organisations, so if they're working with Northern Ireland Alternatives or CRJI or Victim Support or whoever it may be, so essentially the accreditation is linked in with an organisation and the practitioner. So if you are an accredited practitioner in an organisation and leave that organisation, you would no longer be accredited. Or if there was something that was given us cause for concern in terms of the practice of that individual, you know, the accreditation could potentially be reviewed and removed.
How would you see that and know that?
That, well, I suppose as part of this process and with the post of the protocol lead, as well as the work that's being undertaken by the independent referral body through PBNI, there'll be fairly regular engagement and contact with the practitioners, how they're operating. A key element of that post is in terms of kind of going forward, is going to be providing oversight, monitoring, quality assurance in terms of the practice of those individuals. So we would expect to pick those things up as part of that process. Equally, things may be flagged with us either by other practitioners or by criminal justice organisations that are partners that are dealing with these practitioners. So I think there's probably a range of ways in which things would come to our attention.
Okay. Brian?
Okay, Paul's covered some of my questions. So is every application an individual practitioner?
There were, I think, 32 individual applications from a practitioner, and then there were 7 organisational practitioners, and we ended up with 7 accredited organisations and 26 accredited practitioners, and each of those would have been associated with an individual application for the individuals.
Right. And all the CRJ ones previously operated this, is that right? And NI Alternatives, they previously operated restorative justice?
Previously it was CRJI and Northern Ireland Alternatives that were accredited as an organisation, and they would have had individuals working for them. They won't all necessarily be accredited as part of this process. It was a number of individuals that were put forward for accreditation. So
CRJI, is that CRJ Derry, CRJ Newry Armagh, is that part of the same organisation, or are they separate?
They're three separate entities.
They are new.
Yeah, under the old.
They're not new. The CRJ has been operating in Derry for 20 years, but they
That's
don't.
what I'm asking. Is it part of the?
It's not part of CRJI, but they all work closely together.
Were they an existing practitioner? I'm just. My question is about how many of these are new. Is it just is prison in terms of didn't have a contract before? So
I suppose if you look at it in the context of the organisations that were previously accredited, it was Northern Ireland Alternatives and CRJI, who have a Belfast base but operate across Northern Ireland. My understanding is that there was a point kind of since that original accreditation at which CRJ Derry and CRJ Newry Armagh became separate entities in their own right.
They were originally part of that.
They would have been operating previously in terms of undertaking restorative practice. It's not that they're new from the point of this process, if that makes sense.
But new to it is Prison Fellowship NI, TIDES, Victim Support NI.
Yeah.
The individual applications, can we be told who they are? Or
I don't think there's an issue with that, because I suppose it will be published online in due course. So it's Professor Tim Chapman, Sam White and Jim McGrath are the 3 individuals.
Okay.
That are operating independently. And that is to say, all of the other accredited practitioners are associated with an organisation. The names of all of the individuals will be listed on that. Right. We're waiting at the moment just for, I think there's 1 or 2 Access NI checks just to be completed. So once we have those, we'll publish that list. And the names of all of those individuals will be available, and we'll share that with the committee in due course.
Okay. And then just last question. At this stage then, how does it work? Is there another stage to the contracting, tendering of this? Or now they're accredited, are they effectively receiving a contract? Or is it a case-by-case funding, or do they receive some core funding? What
we're doing for the first year, and I suppose very much cognizant in terms of, at the outset we didn't know what the uptake was going to be, what the numbers were going to be like. We're making blanket provision not blanket, but we're giving each of the accredited practitioners, there's an allocation of £10,000 for the year for the cases that they undertake. I think it's probably likely that we will review that at the end of the first 12 or 18 months and look to see what might be the most appropriate model then. It may be that it's on a case-by-case basis at that stage, once we kind of have a better sense as to what the work entails in each of the cases. And that will be done by way of a grant agreement with the organisations and the 3 individual independent practitioners, rather than it is effectively a contract. We in government terms would refer to it as grant funding. So that's the way in which, and that will kind of set out, what we expect from them, what the key performance indicators are, how it will be monitored, what we will want in from them in terms of quarterly progress reports, end of year progress reports, that type of thing.
So they effectively are approved now for a funding contract?
Yeah.
Okay, thank you, Chair.
Okay, Ciara?
Just a couple of wee things, and it's basically around that. Just first of all, when I was looking through the guidance and the practice, there's organisation here is only at level 1, and they need to be supervised by a level 2 or 3 in the guidance. So I'm just thinking, and I know any people can practice at a level 1 without an accreditation, but how are they assisted to be able to move to level 2, level 3 if they don't have within their organisation someone at a level 2 or 3 that needs to shadow their work and stand over their work?
No, I know what you mean. As you say, Prison Fellowship is the organisation that has the level 1 practitioners, but none at level 2. And I suppose that will be looked at in the context of the types of work that, in all likelihood, it will be in the context of cases that are kind of on the cusp of the criminal justice process, which haven't yet reached that kind of formal process. They could be involved in relation to those, and then have those considered as part of the accreditation process going forward.
You won't be having contracts for level 1s, will you?
No, there's no contracts with level 1s.
So there'll be no money in relation to level 1s?
Yes, and in terms of that funding element, it's funding for the level 2 and 3 that are part of the Restorative Justice Hub.
Just then on, see with the current application forms, in my opinion, obviously, and the number of people that applied was basically based on there's very little money around to do this work anyway. So it's like a gradual and it's like a pilot programme at this stage. What percentage do you think that have now gone to accreditation in comparison to the current people who are accredited or in other ways through the Ireland programme is still in the systems? What percentage do we have now accredited through this process in comparison to the wider landscape of those that are currently carrying out restorative justice practice in the north? Yeah. Have you any idea?
No, I know what you mean in relation to that. I suppose the organisations that I would probably have the best sense in terms of kind of the number of practitioners are probably for Northern Ireland Alternatives and CRJI. The folks that are Belfast based but operate across Northern Ireland. I would imagine at the moment we're probably between those two organisations and the others. I would hazard a guess on it's an estimate at best at maybe kind of 15 to 20% of kind of their workforce as such have been accredited. Just based on kind of some of the indicative numbers that we'd had previously in relation to numbers that might have been put forward for accreditation. I would estimate it's around 15 to 20%. So there's fewer people accredited probably than unaccredited, but obviously it's only the individuals that are accredited that would be taking forward the formal criminal justice system work that the department would be funding.
And just in relation to my previous question, the independent application form, so I'm an individual, I apply, I get a level 3, no bother. So I can go out and practice and do this work and I can take contracts on. So who oversees me as an individual?
I suppose again we would envisage that both for the independent practitioner and also as part of the work of the accredited organisations. There'll be a key role in terms of the protocol lead in terms of that monitoring quality assurance in relation to the work that's being undertaken by the practitioners. There'll also be scope for the protocol lead to do, I suppose, on-the-spot inspections for inspections is the wrong word, but to go out and kind of see how that work is operating. We're also intending to have like group supervision, which would be undertaken on a monthly basis, and that would provide an opportunity to probe or tease out some of the if there were any concerns or issues or things that we thought needed to be looked into.
So, in mentioning the protocol lead, obviously she's now left her position. So, is there any latest update on the recruitment to have that protocol lead in place? We
had one out to recruitment for that there, and we have an individual that will hopefully be in post at the start of June.
Okay. Just one final one. I just want to pick on a question Brian asked regarding potential contracts. Did I get this right? Did you say 10k per practitioner?
So for argument's sake, if an organisation had 3 practitioners, it would be, and sorry, I suppose I should provide clarification in relation to that. For the practitioners, where they're an independent, it would go to that individual, where it's a practitioner in an organisation, it would go to that organisation. So if there were 3 accredited practitioners, there would be 30,000, for argument's sake, there would be £30,000 going to that organisation for the provision of the work.
For a year?
For the year. As I say, that's something.
Is that on a provision of so many cases or timescales or hourly rates, or that's just 10k and the organisation decides how many cases they take on, or they just have to take on every referral that they get, or what's it based on? You don't know.
I suppose, and again for the first year, because we didn't know what uptake was going to look like, etc. That is a payment that is being made to the organisations, and they are to undertake the cases that are provided by the department. So it's cases that are allocated
They
from
can
us.
refuse cases because the 10Ks ran out and it's not covering my hours of work. Or are we looking for the goodwill of community organisations? I know I'm quite passionate about this one, and Brian has worked in the community sector as well. You know, if they're accredited in doing the work, they need to be paid for the work that they're doing.
No, I know what
So
you mean.
I'm just kind of, I can understand it's a pilot, it's early days, but handing an organisation 10K, they need to have the power as well to say, well, the 10Ks ran out, and it could run out in 2 months based on
I
the
know what you
workload
mean.
that I've done. So
And I suppose
I'm trying to grapple with
how we kind of deal with that situation. And I suppose in terms of the amount that we were given, we took into consideration the number of cases that we estimated were going to be coming through. So as part of that process, and there's for the cases that are being looked at, there should be co-facilitation, so 2 practitioners would be involved in a case rather than a single individual. But I think we've reckoned that over the course of the year, if the numbers were what we estimated, it would be in the region of, in and around 12 to 15 cases over the course of the year. We would expect a practitioner to take. We may get we may get less than that, we may get slightly more. And I suppose the key thing in all of this is that, we will have ongoing and continuing conversations with the organisations and the accredited practitioners generally, just in terms of the operation of the scheme, how they feel it's going, what's going well, not so well, what we need to be refining kind of thing, So we're very conscious of ensuring that there's close engagement and collaboration with the organisations and the practitioners in terms of taking this forward. And the protocol lead post is really the thing that's kind of critical to that. It is.
I've just want to raise it. I think it's critically important that, particularly when they're doing their quarterly returns, that you're looking at clearly the intensive hours of work, because I know the fantastic work, particularly in Derry, that CRJ do, and that's sometimes morning, noon and night, and mediation and facilitation, and it's such valuable work, but it's time intensive and it's early. So you're basically saying 12 or 15 cases, but I'm conscious some may be a few hours, others can be real intensive work. So I just want to ensure full cost recovery, and and they be valued for the work that they do. So I just want to highlight it. I understand it's a pilot, but just to raise it.
And I suppose that's something that we'd be very keen to do in that first year, is to get a sense from the organisations of what kind of, what is the range of kind of hours involved in these cases. I suppose the other thing that probably may be helpful to flag for the committee is that in terms of this process, it's different to what they would currently be doing. So currently in terms of, I suppose, the engagement that they would have with individuals, it could be wide-ranging and varied. In terms of the criminal justice case, because the focus on the process is around that restorative justice conference, so essentially bringing the 2 parties together, trying to kind of identify what the issues are that they want to go through, to see what kind of outcomes they want from that process. But the focus is very much on the preparation for and getting them ready for that restorative conference meeting, and then the monitoring of the agreement after that. So it's probably going to be a slightly different, there's a different kind of, boundary in terms of what they'll be involved in for this process, as opposed to if an individual was to come to their office and ask for assistance in relation to something. This is very much kind of focused on the particular incident that there has been, and working towards the meeting of
You've
those 2
really
individuals.
concerned me now by your answer to that, because there should be you've concerned when you're saying about those boundaries and it's stricter, because you don't want a process that's tied down so administratively that it loses the hours of the work that that extra that's always needs to be done to ensure it's done effectively for both the victim and the individual as well. So
and apologies, that certainly wasn't my intention.
No.
I suppose in terms of the process, there'll be a robust process gone through in terms of kind of the engagement with the 2 parties, to make sure that they're ready to go through this process. I suppose it's everything ultimately is geared towards kind of bringing those 2 individuals, and this is obviously where both parties consent to this, bringing the 2 individuals together to have that discussion, to kind of go through what has happened, what was the harm caused, what can we do to try and address this. So I suppose there's a slightly different focus to what I think you would have in arranging the engagement that organisations would currently undertake with individuals when they're dealing with them. By no means is it intended to curtail the engagement with them, and it will go through at their pace type of thing.
Well, thank you, Veronica.
No problem.
Okay, that's no other member has indicated they want to ask questions. So thank you very much, Veronica,
No
for
problem.
your time.
Thank you for your time. Much appreciated as always.
Thank you. Okay, members, can I just seek your views then on, we did contemplate and discuss a potential amendment around this with regards to pre-accreditation checks from Cegini. So I just want to take your mind now that we've heard from Veronica Hold and we've asked her questions, what's the intent of committee members around that, and if they still wish to pursue consideration of that potential amendment. Okay, that speaks volumes. Okay, no, I'm content.
Yeah.
We had talked about this a couple of weeks ago.
I have no huge concerns in what I've heard there today, you know, and there's nothing that's flagged up as a concern to me from what I've heard, but unless others are aware of anything.
Yep, Connie.
Yeah, just I agree with Brian, and happy with the department's approach.
Okay. Any other members want to give commentary at this stage? We did talk about this a number of weeks ago, but then we did have this earmarked in for a work programme, and that would have informed us on this. But it was the amendment was a potential amendment around the pre-accreditation checks of Cegini. Cegini balked back at that to say, well, look, we're going to be part of the process as they have a practice, and we'll inspect that. And they didn't want to do the pre-accreditation checks, but again, it was something that was on the boil in this committee, and I just wanted sort of, if we can end it here, that would be a great help to the staff, and then also Liz too, who would be writing it up. So are we content then to let it sit? There's nothing to stop individual members pursuing something, of course, you know that. Mm-hmm. Okay, happy enough that the committee ceases its interest in that.
Mm-hmm. Mm-hmm. Yep.
Okay. You're playing your cards close to your chest, Kira. That's all I can say. Right, okay, moving on then. Agenda item number 7 then is Criminal Justice Sentencing Bill, etc. Bill, written papers. Can I inform members that the committee has received several responses to the call for evidence on the sentencing bill. 7.1, the Equality Coalition submission. The first, which is from the Equality Coalition, co-convened by CAJ and Unison, is at pages 241. The response focuses on part 6 of the bill and the potential for adding an additional aggravated offence of misogyny. The Equality Commission has also offered to provide oral evidence on the bill, so can I ask members if they're content to note the paper at this time and consider further once the committee's call for evidence on the bill is closed? Agreed?
Agreed.
Submission then from Marie Collins Foundation at page 248. The response focuses on the urgent and compelling need for more robust sentencing for technology-assisted child sexual abuse and child sexual abuse material offences. Can I remind members that the committee has already agreed to hear from the Marie Collins Foundation on the bill? The session will be scheduled in due course. Okay. The Rape Crisis Northern Ireland submission is at page 287. The response provides views on several of the clauses in the bill, and it makes a number of recommendations for improving the bill, including a call for misogyny and transphobia to be added as aggravators. Rape Crisis have advised that they would welcome further engagement with the committee in the bill. So can I ask members if they're content to note the paper at this time and consider further once the call for evidence is closed?
Yeah.
Can I then refer members to page 292 of the meeting pack for submission from the ERA committee? The response asks the committee to consider potential impacts and the practical implications of the expansion of community-based requirements within suspended sentences provided for in Part 2 of the bill, the inclusion of those delivering services in rural areas and in agriculture or environmental contexts, such as inspectors or enforcement officers, in the context of the new offence of assaulting public workers, has also been highlighted. Can I ask members if they're content to note the response at this time?
Yeah.
Can I refer members to page 294 of the meeting pack, a submission from the Committee of Communities. The committee supports the bill insofar as its provision touch upon the remit of the Department of Communities and the workers and service users engaging with bodies within that remit, and particularly welcomes the breadth of the public worker provisions at Part 6 and the explicit inclusion of unpaid workers and volunteers. So can I ask members if they're content to note the paper at this time? Refer members to page 299 of the meeting pack. Can I inform members that the Committee for Finance has provided a nil response to the committee's call for evidence on the Criminal Justice Sentencing Bill? Are members content to note? And then 7.7 and 7.8 correspondence regarding Jade's Law. Can I refer members to page 300 of the meeting pack? Can I inform members that the Committee for Finance has provided this committee with correspondence from the Department of Finance regarding Jade's Law? The committee has also written directly to the Department of Finance on this matter. Can I inform members that the Minister of Finance has stated that he is in support of the various calls for reform and has asked officials to undertake detailed policy development with a view to developing legislation that will be ready early in the next mandate. Given the implications that any reform in this area would have for both the criminal justice system and the family courts, the Finance Minister has also asked that his officials engage closely with colleagues in the Department of Justice as the work progresses to ensure a coordinated and workable approach across departments and jurisdictions. So can I ask members if they are content to note the response, or is there any information or clarification required at this time? Members content then? And then 7.9, refer members to page 308 of the meeting pack. Can I inform members that the committee has received correspondence from Mr Dolan, who has campaigned for some time to increase sentencing in relation by death by dangerous driving. Mr Dolan would like the opportunity to appear before the Justice Committee and discuss this aspect of the bill. So can I take members' views on hearing evidence from Mr Dolan? Sorry, Patsy, go on ahead.
I would like to support that. I think you and I both have met Mr Dolan, and he has been a fine advocate for this cause in light of the tragic circumstances of his son's death.
Mm-hmm. So son Enda, you'll all remember and recall. Mm-hmm. So are members content? There is an issue here by there'll be a lot of interest in this bill and there'll be a lot of people wanting to speak to us. Mm-hmm. But this is in the bill. The text's in the bill, so we can take evidence on the clause as opposed to meeting everyone who wants to add other things into the clause. There'll be ways and means that we can do that effectively and efficiently and sensitively, but I think what's different with Mr Dolan is there's something in the bill to actually scrutinise. Is that okay, members? Agenda item number 8 then, police officers' misconduct and vetting procedures update Department of Justice written paper. Can I refer members to page 309 of the meeting pack? Can I inform members that the Department of Justice has provided the committee with an update on progress to introduce legislative amendments in relation to the police officer misconduct and vetting procedures? The Department advises it has carried out a review and following consultation with policing stakeholders, 2 statutory rules have been drafted. One will introduce amendments to the Police Conduct Regulations Northern Ireland 2016, covering 13 provisions, including a code of ethics, and the other will introduce a bespoke mechanism for dealing with officers who fail to maintain their in-service vetting throughout their careers. This was mentioned in the Chamber when we were discussing the Katie Simpson report, and it was a question from an Alliance member who asked this and garnered this information out. The draft statutory rules will be shared with the committee prior to the proposal to consult, with the anticipation that both SRs will be laid before the Assembly in autumn 2026. The Department is also working to finalise the detail of clauses to be tabled at consideration stage of the Justice Bill, which will establish a police board and advisory list and make provisions relating to discipline of former officers. Of course, members, you'll recall that it was us that pushed for that to take place. The paper also provides information on proposals that the Department has not been able to progress at this time. So can I ask members if they are content to note the paper, or if any further information or clarification is required at this time?
Can I?
Yep, go on ahead.
So in the paper it refers to the fact that the request to bring legislation to remove the requirement for the Ombudsman to wait for criminal proceedings to conclude before issuing a memorandum relating to progressive discipline is that due to capacity it's not possible to progress that. I wonder, could we, just in light of the news that we had this week about how, you know, police officers involved in a botched investigation haven't been held to account. If there's anything that we can do as a committee to ask the Minister, you know, what could be done in this mandate, or what attempts that she's made to get this legislation underway, because...
Could I suggest maybe an oral briefing on the two statute on the regulations proposed, and then given the week that we've had, given the reports that we've read, you know, that would widen up and it will be very topical.
Yeah.
Our members agreed.
Yeah.
Clark, are you clear?
Yeah, Chair, then just so it's an overall on all of the issues, including those that can't be progressed then?
Yeah.
Yeah, okay.
Members content with that then?
Yes. So there's no need to write in the meantime, or just to advise the department to be prepared to answer questions on that?
Yeah.
Okay?
Or would you want a written response
I
first?
would push for a written one at this stage because it's a serious admission at this moment in
yeah.
time, and it could take years. So I think we need.
We don't know when we're going to get the oral presentation.
We don't know when we're going to get the
I
presentation.
think if we write in advance to say that we want a written, an oral presentation on this, but then outline the specific concerns and ask for the rationale why.
Yeah.
Is that okay?
Yeah.
Agenda item number 9 is Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021. A review of the effectiveness of Part 1, Year 3 Review, Criminal Justice Inspection, Northern Ireland Report. Can I refer members to page 315 of the meeting pack? Can I inform members that the Criminal Justice Inspection Northern Ireland has provided the committee with a copy of its Year 3 review of the effectiveness of Part 1 of the Domestic Abuse and Civil Proceedings Act, Northern Ireland 2021, the Act. The report found that whilst strategic direction and intent of the Act was well embedded and understood across the criminal justice organisations, there were ongoing challenges in delivering practice that was consistent and sustainable, particularly due to resource and training constraints, something that we were concerned about at the time. The report also highlights training across the criminal justice organisations as a significant concern, and that the quality and consistency of training has declined over time. Really worrying. A central theme was also the voice of the child and the use of child aggravators under Section 8 and 9 of the Act. Children's voices were often not heard in practice, something that I really did push for. Further concerns in the report relate to the data collected and reported by the PSNI, the PPS and the Northern Ireland Courts and Tribunal Service being found to be inconsistent and potentially misleading, and the lack of joined up data across agencies, making it difficult to assess the true extent of domestic abuse and the effectiveness of the criminal justice responses. So something that even we alluded to today, and the awareness and training. However, the report does identify improvements in some areas compared to previous reviews. The report makes 2 strategic recommendations and 2 operational recommendations. So can I seek members' agreement to ask the Department, the PSNI and the PPS for comment and response to the findings, recommendations and areas for improvement included in the Sigini report? Are members content?
Yeah.
Okay, I should go back to it was actually us that pushed for the review into the working of this. So I think this paints a very big picture, especially given the week that we've had. Agenda item number 10 then, correspondence. Can I inform members that there is a correspondence memo and 9 items of correspondence at page 412 to 581 of the meeting pack. Can I advise members that I will draw attention to 7 of the items, and then members can have the opportunity to comment. 10.2, can I remind members that at its meeting on the 12th of March 2026, the committee considered correspondence from an individual regarding delays in the publishing of a report commissioned by the Police Ombudsman's Office into the Police Service of Northern Ireland's response in dealing with vulnerable persons. The committee sought an update from the Police Ombudsman on when the report can be expected to be published. Can I inform members that a response has been received from the Chief Executive of the Ombudsman's Office and is available for members at page 415 of the meeting pack. Can I ask members if they're content that the response be forwarded for information to the individual who raised the matter to the committee? Agreed? 10.3, can I refer members to page 418 of the meeting pack? Can I remind members that at its meeting on the 16th of April, the committee considered correspondence from an individual raising concerns around the operation of family court system and the child maintenance service, with particular reference made to the impact on fathers Members agreed to forward the individual's correspondence to the Committee for Communities for consideration and any action it may wish to take. Can I inform members that the Committee for Communities has responded to advise that the correspondence was considered at its meeting on the 26th of April. The members agreed to send a letter to the Department of Communities to request a response on the issues raised, such as transparency, accountability and flexibility in assessments in relation to CMS. So can I seek members' agreement to request that this committee be kept appraised of the Department of Communities' response on this matter? Agreed. 10.5, refer members to page 446 of the meeting pack. Can I inform members that the Committee for Education has written to all statutory committees seeking views on 2 private members' bills that are currently considering. The 2 bills are the Education Holiday Meal Payments Bill and the Irish Medium Education Workforce Plan Bill. So can I ask members if they are content that the committee issues a nil response to the Committee for Education on both of those bills? Agreed. 10.6 and 10.7, can I refer members to pages 583, relates to 2 separate bills the Committee of the Economy is asking for views on from all statutory committees as part of its scrutiny. The first bill is the Petroleum Exploration and Licensing Repeal Bill, and the second is the Utility Regulator Support for Decarbonisation Preparation Bill. So can I ask members if they're content that the committee provides the Economy Committee with a nil response to each of the bills? Okay, agreed. 10.9, refer members to page 578 of the meeting pack. Can I inform members that the committee has received correspondence from Councillor Catherine Nelson on behalf of the McIlvana and Haddock families, raising concerns about delays in the trial of an individual accused of causing the deaths of Ciara McIlvana and Patrick and Ciara Grimley near Market Hill in November 2023. The delays are due to the ongoing withdrawal of services by the Criminal Bar Association. Councillor Nelson has asked the committee to consider what steps can be taken and advised that she has also written to the Justice Minister and the Lady Chief Justice about the matter. Members will recall that the committee recently received a response from the Minister of Justice about derogations to the ongoing service withdrawal by the Criminal Bar Association after the committee had received correspondence on another case from Pam Cameron MLA. So can I seek agreement to advise Councillor Nelson that the committee is not unsympathetic to the concerns raised but is unable to intervene or become involved in individual cases, and to forward a copy of the Minister's previous correspondence to Councillor Nelson for information, with of course details of that previous case redacted. Are members content with that? Can I just say that the accelerated review of criminal legal aid fees, which the Minister has talked about in the Chamber, was to conclude no later than 27th of April. So could I propose that the committee request an update on whether that has been completed and what the next steps are? And that might even inform us as a committee, and then also be able to inform others that has written to us on specific cases. Members content? 10.10 then, refer members to page 580 of the meeting pack. Can I inform members that the committee has received forwarded correspondence from an individual to the Justice Minister regarding pre-release testing prior to tariff expiry dates? This follows the committee's forwarded correspondence from the Department along with the terms of reference to Mr Little as agreed at the meeting on the 23rd of April. Can I inform members that the individual's latest correspondence to the Minister raises questions about the voice of victims in the review? So can I seek members' views on requesting a copy of the Minister's response to Mr Little on this matter? Members content?
Yeah.
Can I ask members if they are content to note the other items of correspondence, or if anyone wants to bring anything up at this stage? Okay, moving on. Agenda item number 11, Forward Work Programme, 11.1. Can I inform members that the latest draft of the committee's Forward Work Programme can be found on pages 583 to 592 of the meeting pack? Can I advise members that the Department has asked to add an additional written paper to the meeting on the 28th of May on a draft consultation on raising the statutory caps for miscarriage of justice payments? Can I ask members if they're content with the paper, or if anybody... Patsy?
Chair, just one item. On the 28th of May, when we have the consultations coming in on the firearms licensing and bandage system, I see there maybe it's not this way at all, but BASC present first and then the department. Could I suggest, and this is based on previous experience in this matter whenever you and I were both on the committee, that we reverse those and have the department in first, because BASC brings a lot of experience in this matter and a lot of knowledge in this matter, and previously we were misled by the department. There's no point in saying anything else.
Okay, are members content with that?
So
Okay.
who's going in first, sorry?
Pardon?
Who you're proposing comes in first?
The department first?
Department. Mhm.
The department first and then BASC?
Mhm.
But then we can say what, and we can put to the department what BASC have told us if BASC come in first.
No, Connie, my experience in that regard, and I hope the same people still aren't in the same positions, whenever I was on the Justice Committee before, we were misled as a committee. And BASC has the experience because they were there at that time, and I'm not being party political on this. I just want to make sure that we get the true and effective story on it. That's all.
I mean, I'm not trying to like block or anything at all or try and frustrate this. And I've met with BASC and they absolutely have important points to make. It's just about what is the most effective way for us. But happy to hear from other members as well. But just for me, I felt like you'd want to hear from those who have the on the ground, who are affected by these proposals, hear what they have to say, and then be able to put them to the department. But if you think it's more valuable to hear from the department and
Yes.
then hear from BASC, okay.
I think so, because the reality as presented by the department previously and the reality that was on the ground were poles apart, and we were caught in the middle of it where frankly we were told lies, and that had to be retraced by the department itself at that time. And you were there, it was around the existence of what was referred to as a CIFEX report, which didn't exist at all, and we were given assurances by the department that it did exist, and it didn't exist at all. So forgive me for being a wee bit reticent.
No, that's fair.
That's why, and you've met BASC. They bring a professionalism to it and the experience from sports people on the ground. So that's my only reason for it.
I have no problems with that, Patsy, and I do recall that time very vividly. So I have no issue with regards to that, and I suspect this will be an ongoing issue because it is so topical. So even when the consultation closes, I think there'll be a correspondence trail with us and the department anyway. So I'm happy enough with the department going first, BASC going next, and then if we need to write back to the department, then we can do so. I think that would, because I think we're going to write back to them anyway.
Aye.
So I'm content. Any other members want to raise?
I'm content, obviously.
Content?
Yeah.
Okay.
Okay, thanks very much.
Okay, members, any other members want to bring up any other issues on the forward work programme? If not, then agenda item number 12 is chairperson's business. I advise that I have no chairperson's business. Agenda item number 13 is any other business. Can I ask members if there's any other items of business they wish to raise at this stage? If not, then agenda item number 14, date, time and place of next meeting. Can I advise members that next meeting will take place on Thursday, the 14th of May 2026 at 2 p.m. in room 30, Parliament Buildings. The meeting is adjourned.
Committee Room 30. Sound. Committee Room 30. Sound.